seated. All right. Are all the jurors here?
All the jurors are here, Your Honor.
They are here, okay. On Zoom, right?
Yes, sir.
All right, well, so far, he or she's not on there. Okay, there we go. All right, ma'am, hang in there. Can you hear me? Okay, if you can go ahead and unmute yourself. There's a microphone with a red line through it, so if you can just click on that. There you go.
Got it. Can you hear me now?
All right, very good. So we're going to bring the jury in, and then we'll place you under oath, and then you'll answer some questions. All right,
All right.
so let's bring the jurors in.
Your Honor, jury adjourned, jury box and seated.
All right, welcome back, members of the jury. Anyone have any issues with hearing or seeing anything regarding to this case? All right, everyone's shaking their head no. Defense, please call your next witness.
Michelle Justus.
Okay. Ma'am, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Very good. You may proceed.
Thank you, Your Honor. If you would, ma'am, please introduce yourself to our jurors and spell your last name.
Michelle Justus, Justus.
All right, and Ms. Justice, where do you live?
I live in Middleburg Heights, Ohio.
All right, and are you employed?
I am.
And where do you work?
I work at Target.
All right, and did you used to work at Chupa's Supermarket?
I did.
Okay, and how long did you work there?
10 years.
And what did you do there?
I was the cashier manager.
All right, do you know Shelby Nealy?
I do.
Did he used to work at Chupa's Supermarket?
He did.
And what did he do there?
He was a cashier.
All right, I want to turn your attention to the summer of 2016. Shelby was a cashier at that time?
Yeah,
All right, and did you know that he was married at that time?
I did.
All right, and his wife's name was Jamie?
Yeah.
All right. When Shelby would come to work, would you often see bruises, scratches, even a black eye one time?
There were several occasions, yes, when he came in and one time he had a black eye, several times his arms were all scratched and bruised.
Did there come finally a point when you saw it enough times that you wanted to know why he had those marks on him?
I did ask him why he had those marks.
And what did he respond to you?
He told me that his wife was pregnant and that she was supposed to be taking medication. She could not take the medication because she was pregnant, and it made her mean and violent.
And did his wife ever call the store?
She called the store quite a number of times.
And what was her demeanor? How was she acting when she would call the store?
Well, at the end of the day, we never knew what time we were going to get out. We had work to finish, and it was never a certain time. So if he was not out by 9 o'clock, she would continuously call the store, telling us that he needs to come out now, and she was very demanding about it.
Did there ever come a time when she came to the store when you were there?
Yes, there was one specific time that I remember. She parked across the street in the employee parking lot and was yelling across the street that he needed to come out right this minute.
You found out sometime later that Shelby was arrested for killing Jamie, is that right?
Correct, I saw it on the news.
Did that surprise you and the other workers and the people at Chupa's?
Objection, Judge Relevant.
It,
Sustained. If you want to rephrase the question, you can.
That's fine, Judge. Ms. Justice, did you know that while Shelby was working at Chupa's Supermarket, were there complaints, or did you have knowledge, I guess, that other workers in the store had had these same kind of issues and seen the same kind of bruising?
yeah, it was very obvious. We all noticed the bruises and the scratches and his demeanor when he came in.
All right.
A lot of times he seemed, I would have to say the word is defeated.
All right, thank you. I don't have any other questions, Judge.
Thank you. Any cross-examination?
Thank you, Judge.
Good morning, Ms. Justice.
Can you hear me
Good
okay?
morning. Yep.
In terms of the injuries or any violence or the reasons for any violence, all of that was based on what the defendant, Shelby Nealy, told you, correct?
Correct.
You never saw any violence between these two people?
I did not.
And obviously you weren't there at the home to see what was going on and what led to any of these encounters, correct?
Correct.
I don't have any more questions. Thank you, Judge. Any redirect?
Yes.
All right. Thank you, ma'am.
Thank you.
All right. Defense, please call your next witness.
Raul Banasco.
Right here, please, sir.
Yes, blood pressure right hand and seatbelt.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
This way, please, sir.
Just watch your steps. Please speak into the microphone loudly.
Good morning, sir.
Good morning, Your Honor.
Reverend, you may inquire.
Good morning.
Good morning.
If you could please tell the jury your full name?
Raul S. Banasco, Raul S. middle initial Banasco.
And Mr. Banasco, tell the jury a little bit about your employment background.
I have over 39 years in the corrections profession. Started my social services profession in New York in case management with juveniles, and then relocated to Florida in 1988, in which I did 20 years with the Florida Department of Corrections. Started my profession as a corrections officer at the state prison in Orlando, and over the next 7 years served in a variety of positions as classification officer, classification supervisor, as well as a classification supervisor at Polk Correctional, and then promoted to be an assistant warden at Martin Corrections Institution down south. And then got promoted to Tomoka Correctional Institution as an assistant warden 2 for 5 years, and then made warden at Hernando Correctional Institution in Brooksville, and then got promoted to headquarters as a director of training with the Department of Corrections. And after 20 years, was asked to join the Orange County Corrections Department in Orlando, where I served as the major for 2 years, went on to be the chief, deputy chief for Osceola Corrections, did about 25 years in the Florida system, then went over to do some nonprofit reentry work with Bridges of America, and then went on to run various jails in Texas from San Antonio, Fort Worth, Austin, as well as St. Louis. So in the profession for 39 years in the corrections field.
Okay. Working in corrections, and particularly when you are in a supervisory capacity, do you sometimes have to make unpopular decisions?
Unfortunately, being a corrections administrator, I mean, one of the things we know is we are educated, we get certifications as jail managers, corrections executives. We're appointed by many of elected officials, in which I've had many years, served in those positions where you have to deal with adversity in the culture of the corrections profession, where there's inmate abuse or staff negligence, and in many cases, you make some unpopular decisions. I know in my career I've had to do that. In Osceola County, we had an escape in which I had to be the one to be responsible to deal with discipline. My chief had retired at the time, had to dismiss 42 employees because there was an escape that took place of a violent life inmate at that jail. And at that point, you upset some folks. So you upset associations. Also in St. Louis, one of my other assignments, where I had to take actions and command staff, actually some of them are serving federal prison because of violating civil rights. So at the end of the day, being a corrections administrator, it's not a popular job, it's a very tough job, and we do get attention, and often it's not what is perceived in the media, but we have to make sure public safety and be good steward over our taxpayer dollars.
And some of the things you just talked about, did that actually make the news media and
Yes, Osceola County did, that's my home county, in which there was a little blurb that I was fired, or actually a racist, because I actually terminated all races, Hispanics, African Americans, and Anglos. And in St. Louis, because I had to clean up the mess, that also made some news.
Okay.
But since then have served in many other capacities, but it's just the call of the job.
All right. Were you fired?
Never.
Okay. After completing 39 years of working in corrections in the various capacities that you described to the jury, have you done some consulting work where you have been recognized by courts as what's referred to as a prison expert?
Yes, I have.
Okay. And where have you been recognized as a prison expert?
On state of Louisiana, Georgia, South Carolina, about the majority of all the counties here in Florida, as well as in New York and some other, I'm trying to think what else, California, I've done some work as well.
Okay. And prison expert, presumably because of the things you learned in the 39 years that you worked for the various corrections institutions.
Correct.
All right. Particularly as it relates to Florida and the Florida Department of Correction. That's where people end up going when they're convicted and sentenced to prison. Is that correct?
Yes.
All right. Whether they're sentenced to serve a life sentence without parole in the Florida prison system, or whether they're sentenced to death row, that's all within the Florida Department of Correction. Is that correct?
Yes.
All right. And did you develop an expertise both as it relates to general population in the prison setting and also death row?
Yes.
Okay. Are you aware of how many inmates are currently serving life sentence in the Florida Department of Correction without possibility of parole?
Approximately 267, 68, according to the Department of Corrections website.
Life or on death row?
Excuse me, on death row, 267 life. Lifers, we have about 11,000 of the 88,000 population as of today.
Okay, so about 11,000 serving life sentence without possibility of parole.
Correct.
When you're serving a life sentence without possibility of parole, that means ultimately the only way you're leaving is when you die,
Correct. You're
In a pine
going out in a
box.
body bag.
right? Oh, yes?
Yes, sir.
And that's true whether you're on death row or serving a life sentence, correct?
Correct. Yes.
All right. Now, could you describe to the jury the life in prison for an inmate serving a life sentence in general population? What is that life like?
Being a warden at several maximum security prisons, a life of an individual serving life in the prison system and facility is, you get up at 4 o'clock in the morning, it's time to march to the chow hall. You will have about 5 to 6 minutes to eat your meal, and then you will move forward back to your housing unit for count. At that time, after count's clear, you will go to work. Every inmate in the Florida prison system, with the exception of death row, is required to work up to 60 hours a week. There is no option. They are the individuals who have to keep the upkeep of the prison. They have manual lawnmowers. We have to provide 15,000 meals a day, launder clothes. We keep up with the painting, anything to do with these aging prisons. At the end of the midday, you have another count in which you have to go back to your dormitory. You're told to sit on your bunk. You get counted again. And we go through the same process in the afternoon for the evening. Throughout the process, you have to follow the rules and regulations of the prison system. And if you have time, then you can benefit from your privileges, which are visits on the weekends or weekdays, have access to tablets, and anything else as far as recreation. But pretty much 24/7, you're told what to do, you're required to work, and if you refuse to work, then there's consequences for that.
When you're serving a life sentence in general population, do you have your own private room?
No.
Do you have your own private television?
No.
Okay. when you first arrive, and are you assigned any particular type of work?
So if I can walk you through the process, when an inmate is sent to a state prison system, they will end up at a reception center. In this geographical area, they end up at the Central Florida Reception Center. Within the 6 to 12 weeks, you're processed, your head is shaved as a male. As a woman, your hair is trimmed down very short, and you will go through an assessment process. You end up at a permanent prison where the need and the vacancies of beds are at, and basically you go through an assessment process in which you are assigned a housing unit. You're assigned an environment where you sleep with other inmates. It's a communal environment. You share the same toilets, same showers. You have to have a community environment to watch a TV. There is nothing individually. Basically, it's almost like the military bunks. You're required to work and live within other inmates within that population.
Is there a particular type of job that generally is assigned to a newly arrived inmate?
Yeah, we often say in classification, you better start at the bottom and work your way up. You're going to cook, and you're going to learn how to cook, or you're going to be pushing a lawnmower out in 100 degrees heat. After a period of time, anywhere from 3 to 6 months, when you show some responsibility, where you're showing up because it's a job. You don't get paid, you don't get compensated, so you're required to be evaluated by the officers or the civilian staff, wherever you're assigned, and after a period of time when classification reviews your records, and you can put in for more positions that are available, whether they're in the wellness program, in the library, or working in the chapel, or working your way into other responsible positions, then they'll do an assessment of you from classification, and they will give you that opportunity, but you have to work your way into those jobs of responsibility to show your worth.
Okay. Is there a concern when, if you're provided, you're working, and you know, whether it's the initial job of pushing a lawnmower, or other jobs that you may get promoted to based on behavior, right?
Correct.
Your ability to follow rules?
Yes.
Okay. How about access to tools that might possibly be used as weapons?
Well, that has changed drastically in the Department of Corrections. In 2003, when I was a warden, we had an unfortunate situation where an officer was murdered. So anyone who is serving a life sentence or have any kind of violent crimes will never have access to Class AA tools. Those are hammers, screwdrivers, any pliers, anything that can harm someone. Those individuals will never have access to those tools. They only have access to their hands, and basically that's about it, a broom maybe.
Okay. Let's switch and let's give the jury a little bit of insight into what happens to someone who is sentenced to die by execution in the state of Florida. What happens when they leave the county jail, and so to give them the preview of that.
So when an individual is sentenced to death, the process is a little slightly different. They will not go to their local reception center. They will go straight to RMC in Rayford, Florida, where they would be processed within 24 hours. From that point, they're taken over to either FSP or Union Correctional Institution, in which they're placed in a single cell after they're assessed, and they're provided with their own environment. They basically live in an environment that's 5x8. Now, keeping in mind through the classification process, so if they're sentenced to be executed, they have two methods in the State Department of Corrections, either by lethal injection or the electric chair, as we often call it, sparking. So they only have one time, one opportunity to decide the method of which they want to be executed. If they choose not to, the default as of February of this year is to be through lethal injection.
Okay. So you indicated that someone who's on death row is in basically a 5x8 cell.
Correct. 5x8. The individual has their own TV. They have their own sink, their own toilet. We often call it the bread and breakfast of the Florida Department of Corrections, because their clothes is starched and ironed and brought to them. Their meals are brought to them. Chaplaincy services are brought to them. Classification medical come to their cell for the most part. But they're also allowed to have some other liberties, which has changed in the last several years, where now inmates on death row have their own tablets. They can communicate They can text family and friends. They also have a lot of out-of-cell time in which they have day room, recreation, and they also have contact visits as well. So now they have mirrored the same environment of those serving life and general population, with the exception that they have their own cell and don't have to have any kind of shareable environments.
Okay, so basically they have their own private cell.
Yes,
You'd indicated, I believe, that there's 11,000 people serving life, approximately, and about 267 people on death row,
yes,
awaiting execution.
yes.
Okay. Is there an sort of an average period of time that people would stay on death row? Do you know?
Last time I reviewed Department of Corrections records, about 23 years they sit on death row before they're executed.
Okay. Did you, in preparing for your testimony here today, did you review some Pinellas County Jail classification records? And I marked that they've been marked as Defense Exhibit 25A and B, which is in this folder. Did you review
Yes.
these?
Yes,
Okay. Earlier, we took a look at Exhibit 26, which is the medical records. It's basically 2 banker's boxes, right?
yes,
Did you also review those in preparation for your testimony?
yes.
Okay. Your Honor, at this time, we would move to enter into evidence Defense Exhibit 25A, B, and 26.
No objection. All right, they're admitted.
Okay. In reviewing the records, did you notice that for the majority of the time that Shelby Nealy has been in either Pinellas County Jail or Pasco County Jail, for the majority of the time, not the entire time, but for the majority of the time that he was in protective custody?
Yes, he was.
All right. Based on your experience in corrections, and you have an experience not only at the Department of Corrections level, but also at the local level, right, in Orange
Yes.
County? Based on your experience, will a jail facility or the jail administration place someone in protective custody just because the person wants to be in protective custody?
No,
Okay. Might they put someone in protective custody because of the notoriety of their case?
yes,
Might they put someone in protective custody because the person is of small stature?
yes,
Okay. And is the primary concern for protective custody safety?
safety for the staff and the overall security of the jail.
Okay. All right. And when you're in protective custody, you have your own private cell, right?
For the most part, yes.
For the most part. In the local jails anyways.
And most jails, they're designed a little different, but for the most part, they usually have their own cell, or they have a bunkie that's also protective custody. It's a smaller unit.
Okay, all right. Did you review the classification records and the jail records? In reviewing those, were you able to determine whether or not Shelby Nealy had any behavior problems while incarcerated here in the Pinellas County Jail or Pasco County Jail?
No, reviewing the records, there was no indication that he received any kind of negative reaction, nor any kind of disciplinary reports. In fact, looked at the incident reports, how they shake down the cells, which is a common practice in corrections, to make sure there's no contraband, and all the shakedowns that took place that he was involved with, there was no contraband. So he didn't have anything that was concerning as far as his violating any rules or not following the procedures as required by both jails.
Okay. And unfortunately, both in the local jails and in the Department of Corrections, contraband does surface.
Yes, it does.
Contraband can be narcotics,
Yes,
cigarettes,
yes,
and you know, any object that's not officially provided by the facility itself.
yes.
Okay. And so during the 6 years that Shelby Nealy has been in the county jail, there's been no problems with Mr. Nealy?
Not according to the records I reviewed.
And when they go in and do these surprise shakedowns, they've never found contraband in his cell?
Correct.
Okay. Is that important for purposes of your evaluation as to how Shelby Nealy might do should he be sentenced to serve the remainder of his life in the Florida Department of Corrections?
Yes, when I sit down and have my in-person structured interview, review the records, the adjustment that takes place at a local detention center also will bleed over into the state prison system. So I review his incident reports, any type of disrespectful behavior amongst the staff, volunteers, or other inmates, any kind of violent acts or incidents involving anything related to physical contact with offenders or staff. That's very important because it shows the behavior while they're in that environment. Are they performing or acting in a positive institutional adjustment? So those are all indicators that they're following the rules and abiding by what is expected of them. Yes.
Okay. And I should have asked you, so we talked about the fact that you reviewed records, right?
Yes.
Did you also interview Shelby Nealy before you finalized any thoughts and conclusions about his case?
Yes, met with him on May 3rd, 2025 at the Pinellas County Jail, had an in-person structured interview with him.
Okay, and what's the purpose of that interview?
The purpose of that interview, someone with years of experience like myself, I take away a lot from their demeanor, their posture, communicating with them, learning a little about their background, where their family's from, what is his behavior or his concerns while he's in that environment. I don't talk about the crime because my role is to assess their prison and jail environment. Also review the Department of Corrections. He was technically never in there, he had another charge. But basically talk to him and see where he's at and what he's done while he's been in the county jail, look at his education, any of the achievements that he's tried to do positively, as well as discuss any negative behavior that I come across in the records.
Okay. And what did you walk out with? What were your thoughts after you met with Mr. Nealy as it relates to the purpose that you're here?
Well, what I walked away from, in my opinion, is you had an individual who's been in the county jail for over 6 years. He's following the rules. He was in Pasco County where we had no issues, but also during my discussion and verifying documents while he's been sitting in the county jail, he's done some positive things. And as a jail administrator or corrections professional, he went ahead and obtained his high school diploma, his GED. He went ahead and got his certification as a paralegal. So he used his idle time to have something positive to focus on. At the end of the day, didn't see anything negative. We talked about the fact that he was in protective custody, and that was something that many of us who work jails, we do that because of high notoriety cases. But at the end of the day, he was very respectful, talked about his mother, his stepfather, who was very supportive, and talked to me a little about his upbringing and his religion belief. Basically, get a good assessment on his overall personality, and the individual in front of me, did it mirror the documentation I was reading?
Okay. Do all inmates in the Department of Correction engage in productive behavior?
Unfortunately, not.
Okay. Many continue to get in trouble even once they're behind bars?
Yes, they do.
Both at the local level and at the Department of Corrections?
Yes.
Okay. But that was not the case with Mr. Nealy?
No.
Okay. Is it your opinion that in the event that the jury was to allow Shelby Nealy to die in prison of natural causes, that he might be able to be productive and helpful to others?
I think so. In reviewing his records and in talking to him, one of the things that he talked about was wanting to serve as a catalyst or a mentor to the other inmates. And one of the things we know in the Florida prison system, as a former warden, when inmates come into all our prisons, they go through an orientation process. And we have this program known as lifers. Those inmates who are serving life, they sort of have an orientation with these individuals coming in. Many of them have a short sentence. And the expectation as a warden is that they give them guidance, let them know, look at me, I'm going to die in prison. This is not what you want to do. And when you get out, do not reoffend. Don't find yourself in this circumstance. And also because they're lifers, there's programs in the prison system that we can use them to our benefit. We don't have enough teachers. He's an individual who has a high school diploma. If he works his way into positions of more trust, he can even work in the education department, provide as an education aide to help other inmates get their high school diploma, as well as even in the library. So there's some things that he's worked on while he's been in jail that the Department of Corrections could benefit from.
Okay. Assuming he did all those things, assuming he advances and is teaching and sharing and helping and he's a model prisoner, does that have any impact on him dying in prison should he be sentenced to life in prison without parole?
It would be the same outcome, sir.
Okay, he would die in prison
He's
regardless.
going to die in prison.
Did you discuss with Shelby Nealy the idea of being in general population?
Yes, I did.
Okay. Did he tell you that he was not concerned about being in, that he was okay with being in general population?
During our, from what I remember, he said he didn't have an issue with it. He just
Okay.
wanted to be productive.
Okay. Do bad things unfortunately happen in prison as well?
Yes,
Violent crimes happen in prison?
yes,
Okay. He's of small stature, right?
yes.
Despite the fact that he told you that he was not concerned about going to prison, is it your impression that maybe part of the reason why he has been wanting to remain in protective custody is that he is concerned?
Well, in talking with him, he was concerned at the local level, but not, I didn't indicate if he got sent to the prison system there was a concern.
Okay, all right. So from what he told you, he didn't tell you that he was concerned?
No.
Okay. And when someone goes to prison, and when there's a court hearing and people testify, sometimes the information that's provided in an open courtroom may become available in the prison setting, right?
There is no secrets in prisons and jails. Yes, sir.
Okay. And you know, the idea, if he was to say that I'm afraid of going to prison, could potentially cause problems for him in general population of prison.
Yes.
Okay. Have a moment, Your Honor.
You may.
That's all I have. Thank you.
Thank you. Any cross-examination?
Yes, sir.
Good morning, Mr. Banasco.
Good morning, sir.
You currently serve as administrator for the Travis County Jail in Texas, right?
Yes, sir.
Okay. And in that position, you're a public employee, right?
Yes, I am.
Okay. But you also make money sort of moonlighting as a defense expert for cases like this, right?
I don't think it's moonlighting, but I'm an adjunct professor, expert witness, and actuary, and auditor.
Well, this is not your full-time job,
No,
right?
this
Your
is
full-time
consulting.
job is to be a public employee, administrator, or at the jail,
Correct.
right?
Yes.
Okay. And you make between 20 and 25% of your annual income from doing consulting work and testifying like this for defense attorneys, right?
Approximately, yes.
Despite being a public employee at that jail, right?
Yes.
And you've never been hired as a consultant for cases like this by a prosecutor's office, have you?
No.
And you've been doing this sort of work for decades now, but for the past 5 to 8 years, you've focused on resentencing and death penalty work, right?
Correct.
So you do this in multiple states, right?
Yes.
And isn't it true that you expect to have made more than $5,000 off your work in this case alone by the time you finish testifying?
Approximately 4,200 as of today. Yes, approximately.
So more than $4,000.
Yes.
And none of this testimony is part of your public position, right?
No, it's not. I take leave when I do this work.
So you testified today that you reviewed the defendant's jail records, talked to him, and essentially you believe he would be a well-behaved inmate in prison, right?
All the records indicate that, yes, sir.
And those same records show that due to the notoriety of the case, he's been in protective custody for essentially the entire time he's been in the county jail, right?
Yes,
So in reality, Shelby Nealy has not had much interaction with other inmates while being in custody. Isn't that right?
yes,
And in your experience, the rate of disciplinary problems for inmates in protective custody is less than inmates in general population anyway, right?
for the most part, yes.
Because in your experience, you often see inmates in general population engage in fights and what you have referred to previously as gladiator school behavior, right?
Yes,
But that's not possible without access to other inmates, right?
yes,
So it should be no surprise that Mr. Nealy hasn't had a history of those sort of violations because in reality, he's had little opportunity to misbehave, hasn't he?
correct. But if I,
In your opinion, you feel that it would be better to put him in general population, and I believe you've used the term sweat equity in his sentence in the past, right?
yes,
And that sweat equity wouldn't involve helping anyone in the community outside the prison, would it?
absolutely not.
Okay. So the jobs he'd be doing would, at least in the beginning, be cutting grass in the prison or making food for other inmates in the prison, right?
Yes,
And you said none of those jobs would involve him having access to hammers, right?
correct. Class A, AA tools, as we refer to them.
Okay. Now, you mentioned in your direct examination that if he gets a life sentence, he'll never walk out of the prison. That's it, right?
Never.
But isn't it true that laws can change, sentences can be commuted, and you know that inmates who've been sentenced to life have actually been released from prison, right?
Those who've been sentenced to life with parole eligibility, I'm familiar with those. But in my experience, I haven't seen someone in my years serving life with no parole be released.
But Mr. Banasco, you said you're an expert in this, you teach this, you've researched it, and you know that that's happened, don't you?
Oh, there are cases that cases are acquitted or they go back and they do get released, yes.
And you're aware of what a sentence commutation is, right?
Yes.
And that happens too, right?
Yes, it does.
Now, Mr. Banasco, I think you talked a little bit about the controversies after you've exited some of your previous positions, right?
Yes,
And some of the complaints against you have involved allegations of a lack of professionalism, a lack of integrity, and a lack of ethical conduct, right?
according to the media, yes.
Well, not only according to the media, but according to the leadership staff of your prison, right?
Be specific.
Do you recall the letter signed by 55 members of your staff in St. Louis to the county
That's St.
administrator?
Louis County Jail, that was anonymous, yes.
That was-
That's part of the whole thing, the whole complaint, that I was cleaning house, yes.
May I approach the witness, Your Honor? Mr. Banasco, could you flip through what I've just handed to you? Okay. Do you recognize it?
Yes, I'm familiar with this.
Okay. Now, you said that those complaints were anonymous, right?
Well, anonymous because it was all based on basically culture shift and nothing factual.
Didn't the document that you just reviewed list the names, the titles, and the signatures of 55 of the employees of that jail?
Yeah, 55 out of 500, yes, sir.
If it lists the name, the rank, and the signature of those employees, does that sound anonymous to you?
Excuse me, let me correct my word. They were non-factual complaints.
So you disagree?
I disagree.
Okay. Now, you also said that you based your decision that this defendant would be a good inmate on your interview with him and your review of his jail records, and you did not review anything about his cases, right?
Correct.
So you didn't review any of the reports detailing how he killed 4 people?
No, I just read, the only thing I reviewed was the booking sheet, which shows that he was charged.
Okay, and you
and
didn't
booked.
review any other criminal records or anything of that nature?
No.
But you're here to tell the jury that the defendant would make a good inmate anyway, right?
Based on his adjustment in the county jails, yes, sir.
And that testimony today comes at a cost of $225 an hour, right?
For testimony, yes.
And none of that is part of your job in Texas, is it?
No, it's not.
Nothing further, Your Honor.
Any redirect?
The hourly rate that you receive for your services, that's a rate that's approved by the state of Florida?
Yes,
It's one that we have to seek permission from the court and from the state of Florida for you to get paid.
yes, sir.
And it's what you get paid when you testify in these type of cases, right?
Yes,
Okay. You were asked if you had ever been hired by the prosecution in these type of cases, right?
yes,
Okay. Certainly, would you be willing to consult with the prosecution? Should they want to talk to you?
yes, I would.
Might you be able to help them educate jurors about death row?
Yes,
Okay, because you're familiar with it.
yes, I am.
Okay. And the difference between life in prison and death row, you would be able to educate them about that as well, right?
Yes,
Okay. Now, you were asked about the fact that laws may change, right?
yes,
As it relates to whether or not he's going to die in prison or not.
yes,
Okay. Currently, the law is he's going to die in prison.
yes,
Okay. And what, as it relates to laws changing, the death penalty could change too, right?
correct.
It could be abolished.
Yes,
In fact, it's abolished throughout most of the world, right?
yes,
And throughout most of the United States.
yes,
Okay. Individuals who are in protective custody, I think you indicated that generally they get in less trouble than people that are in general population.
yes, because the population is a lot smaller.
Sure. And with the exception of about 2 months in Pasco County, where Shelby Nealy was in general population, he's been in protective custody.
Yes,
Okay. But during the 2 months that he was in general population in Pasco County, did he get in any trouble?
no, in fact, in reviewing the records, at one point, the classification department had classified him that he would be eligible to be a trustee.
Okay, because of his good behavior.
Correct.
And what's a trustee?
Trustee is an individual in a jail environment that they help with the food trays, clean up the dormitories, those auxiliary, almost like in a prison, orderlies. Basically, they've showed good behavior, and they let them do some of these higher responsibilities.
Okay. Despite the fact that people in protective custody may get in less trouble because they're in protective custody, do people in protective custody from time to time violate the rules of the jail?
In my years of experience, yes, they have, both in jails and in prison.
They get sanctioned with what's called DRs?
They're required to follow all the rules to avoid any disciplinary report. Yes, sir.
Contraband sometimes is found in their cells?
Yes.
Okay. None of that ever happened with Shelby Nealy over the past 6 years.
None of the records indicated that.
Okay. I believe you were asked by Mr. Doig about the work that inmates have to do, the 60 hours a week that, with the exception of people on death row, but people serving life, they have to work, right?
Yes.
And you were asked the question of, that doesn't benefit anyone outside of the prison system. Was that, you recall that question?
Yes, I do.
Okay. And I believe your answer was, yes, it doesn't benefit anyone outside the prison system, right?
Correct.
Okay. However, is it not true that the people that work within the prison system benefits our society in the sense that it saves the taxpayers funds that are required to run the prison?
That is correct. Yes, sir.
You were asked about this being a second job. you asked about, it was described as moonlighting.
Yes.
Okay, that might be one way to describe it, right? Okay, but the bottom line is, there's nothing wrong with having a second job, right?
No.
Some people have 3 jobs,
Hey, I've raised 3 kids. I've had to.
okay? And does the fact that you do have this second part-time job, does that interfere with your ability to do your other job?
Absolutely not, because I take leave to avoid any kind of impropriety views. No, correct, nothing at all.
In the 39 years that you worked in corrections, did you ever see an inmate who was convicted and sentenced to die in prison of natural causes for a brutal murder who was released from prison?
In my years of experience, no, sir.
Okay. That's all I have.
All right. Thank you, sir. You may step down.
Thank you, Your Honor.
Or you have questions?
Mr. Banasco, you said that you've never seen anyone sentenced to life for something like this who's gotten out. Are you familiar with Nathan Ramirez?
No, sir.
So you're not familiar that he was sentenced to life for a brutal murder and is now walking the streets?
No, sir.
Nothing further.
Objection, Your Honor. Can we approach?
Please.
We don't execute juveniles, right?
No.
Okay. There was a time in our system of justice where we would sentence juveniles to life without the possibility of parole.
Yes.
The United States Supreme Court said we don't send juveniles to prison for the rest of their life without an opportunity to maybe be paroled, right?
Yes.
Okay. The individual who the prosecutor just mentioned, you said you're not familiar with his name, right?
No, I wasn't.
Okay. Would it surprise you that he was one of those juveniles?
Now I know.
Okay. And what happens in those cases is the juvenile comes back with lawyers, sees a judge, and presents what the person has done while incarcerated, right?
Mm-hmm. Yes, sir.
And then a judge decides whether or not that person should be released, right?
Yes.
Does not apply to adults.
No.
Shelby Nealy was an adult when he committed these horrific crimes, right?
Yes.
That's all I have.
All right. Thank you. Sir, you may step down. Defense, please call your next witness.
Paul Swensen.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Please swear, please, sir.
Please walk the steps. Speaking to the microphone that allows you to Western Florida.
Good morning, sir.
Good morning, Your Honor.
And
Good morning.
Good morning.
Could you please tell the jury your full name?
My name is Paul Swensen. Paul James Swensen Jr.
Okay. You don't have to give your address, but where do you live?
6007 Morningside Drive in Parma, Ohio.
Okay. Are you nervous?
I'm very nervous.
Okay. And that's maybe why you didn't hear me when I said you don't have to give your address. It's okay. How do you know Shelby Swensen?
He is my son, my first son.
Tell the jury how you first met Shelby Swensen.
I was dating his mother. It was our third date. Our first date was kind of like a cookout amongst friends on her side and my side. And we were able to have a second date. It was going to be a company party for my friend's wife and for my wife Lisa for a company party. And we were able to immediately find a connection. And so it didn't take too long to decide that we would like to have a third date where I would meet Shelby, because we knew that in our conversations that was definitely going to be a part of the relationship. If I was going to be with her, it was going to be a package deal. She loved him, and if I wasn't into him, I was going to be a no-go. I'm pretty certain of that.
Now, before you met Shelby's mother, and before you met Shelby, did you grow up in Ohio?
I did.
You're a Cleveland Browns fan?
I am.
Okay. Did you serve in the United States Marine Corps?
I did.
For how long?
4 years.
Okay. What did you do in the Marine Corps?
I was a helicopter crew chief at 6172. I was a crew chief on CH-46 Sea Knights.
Okay. And when you left the Marines, what kind of work did you do?
I started going to college full-time and seeking out employment at large corporations to have a career, not just a job.
Okay. And when you met Lisa, Shelby's mother, were you working?
I was.
What kind of work were you doing at the time?
I was working at a large company in communications, and it was a career-type job. And so much, in fact, that's why I quit college full-time. I couldn't do both.
Okay. And what was it that you did?
I am a technician. I work outside. I've been outside the entire time. I do installation and repair for services for customers, both business, residential, of all types of needs of any kind of communication. I basically maintain anything that's a cabling or a network of this company outside of their buildings, all the way to our customers' needs.
Okay.
And I meet the customers head on, so I'm not just dealing with the technical side, but also the relations of the customer's needs.
And at the time, you had lots of coworkers doing similar type of work?
Yes.
And now it's kind of a job that's a dying occupation?
It is.
Okay. Let's go back to the first time you met Shelby Nealy. How old was he?
He was 3 years old.
Okay. And were you nervous?
No, actually I wasn't.
Okay. Well, were you single at the time?
I was.
Did you have any toys at your house?
I did when he came over.
Sure, but before he came over, did you have any toys?
No, not one.
Okay. So before he came over, did you go out and buy some toys?
I did.
All right. What kind of toys did you buy?
Big Tonka truck, because I know he's a boy. And I got a bunch of smaller things. I don't remember all of the items, but I do remember the Tonka truck the most because he took to that toy.
You
But
enjoyed
yeah.
it?
Yeah, and there were plenty of toys there. I kind of went a little crazy with how many toys I bought.
Okay. And you went a little crazy because the love of your life was the mother.
Yeah, I was very, I never had felt this way about anyone until Lisa. I just felt there was something very special, and I wanted to make this work.
Okay. At some point, do you buy a home, the home that you're in?
Correct.
All right.
Yeah, our first home.
And how long ago was that?
That was in '98.
Okay. So several decades ago.
This chair's falling. Yes,
Is the chair okay?
it's falling down.
Okay.
If I can,
You want to stand up and see if we can?
I'm fine. It's just
Okay.
I just noticed it.
Okay. Is that the home where you raised Shelby Nealy?
Yes.
Did you do, you know, do you think you did the best you could to be
Oh,
his father?
absolutely, 100%. I gave everything I could.
Okay. You guys went on trips together?
Oh, yeah, absolutely.
In particular, where would you normally go every year?
Family, so we would go more west along Lake Erie for Lisa's side of the family there. My family's kind of spread kind of close though to where we were, but all of my family, and then of course Texas, which is the other part of Lisa's family. And we did some other trips where, yeah, I think, you know, a lot of camping and stuff. We didn't do a lot of travel because we were trying to use our funds to build our house, you know, get things underway, you know.
And finances are not always easy, right?
Yeah, I'm an hourly wage type guy. I started out at the bottom and I had a family to feed. It's a lot of work to make a dream come true. So I worked very hard. I did a lot of overtime, and I did everything I possibly could to not waste money either, to spend it wisely. And going out on big trips and stuff like that wasn't sensible, but camping was. So,
How would you describe your son Shelby as a young boy?
he was a lot of energy. He was very happy. He was wild, very active. He was a handful almost.
Okay.
He was wild. Yeah, it was a lot of fun.
All right. You say he was a handful. Was there a point in time where he was diagnosed with ADHD?
Mm-hmm.
Yes?
Mm-hmm. Yes.
And I'm going to ask you, instead of saying
Yes.
mm-hmm, if you
I'm
can
sorry,
say yes,
yes.
or no
Yes.
when it's appropriate. Did he end up at some point being medicated for the ADHD?
Yes.
Okay. Did he have difficulties in school?
Yes.
Okay. Did he misbehave from time to time?
Yes.
Okay. Describe to the jury, what are some of the things that he did as far as misbehavior is concerned?
In school or
Both
just
in
in
school
general?
and at home, that you were aware of?
He might take something from another kid's at the school, like a game or something like
Okay.
that. Typical kid stuff. I'm
Stupid stuff, right?
Yeah, yeah.
Okay. And did he always listen?
No.
All right. As he grew older in his teenage years, up until the age of 15, had he ever met his biological father?
No.
Okay. Do you recall a period of time where, shortly before he's 15, or right around the time that he's 15 years old, where there's conversations about him possibly meeting his biological father?
Yes.
Were you aware of the circumstances that caused Lisa and Shelby to move from Texas to Ohio?
Yes. She didn't tell me. Yeah.
Lisa told you about those circumstances at some point?
Absolutely, yeah.
Okay.
It didn't take long, but she wasn't like bringing that information right away, of course.
Not
It's
something,
complicated.
not something she generally wanted to talk about necessarily?
Sure.
Okay, but she told you about it.
Right, when she was comfortable.
What do you recall her telling you about what happened in Texas with the biological father? His name was Bobby, right?
Correct.
What do you recall? Tell the jury what you recall Lisa told you about those
It
circumstances.
didn't take very long, so I hope you understand that it didn't take long for her to feel comfortable with that because she was so mature, but she was telling me horrific things, how he had taken a knife to her neck, how she had to deal with a glass table that was in their apartment be completely shattered, and him threatening her life and making her on her hands and knees dig into the table or to look for keys. He was a dangerous man.
Okay. And ultimately, does Lisa tell you that he ends up fleeing Texas
That's correct.
with her mother and Shelby and going to Ohio?
Yes.
And how old roughly do you think Shelby was when she fled Texas?
Just under 1.
Okay, all right. So when the discussion takes place about Shelby possibly meeting his birth father, biological father, Bobby, around the age of 15, are you guys concerned?
Absolutely. 100%, yes.
Do you recall Lisa wanting or feeling a little bit more comfortable about the idea when she was able to speak with Bobby's wife about Shelby going there?
Yes.
Okay. And do you recall Bobby's wife's name?
I do not.
Okay,
to be
we'll
honest.
ask Lisa about that, that's fine. Does Shelby go and visit his father, his biological father, in Texas?
Yes.
Recently, have you learned of some things that happened while he was in Texas?
That I did not know, yes.
Okay, what's that?
About Bobby's wife.
What about Bobby's wife?
About her seducing and having sex with Shelby.
Okay. Shortly before Shelby turned 17, or I think, or is it the day after Shelby's 17th birthday?
It was the day after his
Okay.
17th birthday.
What happens the day after Shelby's 17th birthday?
Shelby tells us he's completely broke down, that his father, biological father, passed away. He killed himself. I guess he shot himself in the head.
Okay. Did he seem devastated by that?
He was completely devastated. He was completely broken. I had never seen Shelby anything like this. Of course, we wanted to console right away.
I'm sorry?
We wanted to console him right away.
Sure.
Immediately. Yeah, I mean, he was completely broken. I mean, completely red in the face. And I had never seen him ever in my entire life like this. I haven't.
It makes sense to be upset and sad when a parent dies, right?
Correct.
But did he seem to be, I mean, almost beyond that?
Without a doubt. He started saying how it was his fault, or that he felt he could have done something.
Okay, all right. Said it was his fault?
Mm-hmm.
Yes?
Yeah, and that didn't make any sense, but I mean, it was like, it's ridiculous.
Okay. Did it make more sense when you learned recently
Yes,
about
it did.
the sexual abuse?
Yeah, and so many years ago, I never knew this.
Okay. After that, do you see changes in Shelby that are not good?
Yes.
Does he get involved in relationships with people that are not good?
Yes.
Your Honor, the Defense Exhibit 27 through 57, I'm not going to go through each and every one of them, but they're photographs that I believe the state has no objection to us introducing. So at this time, I would move into evidence Defense Exhibit 27 through 57. Make sure that's accurate.
Any objection? No objection. All right, they're admitted.
show you Defense Exhibit 28, which is one of those photographs. Could you tell the jury, who do we see in this photograph?
That's myself, Lisa, Shelby, and Alex.
Alex is the little baby?
Yes,
That's your second son, right?
correct.
Okay. You indicated that Shelby Nealy, your son, became involved in some troubling relationships
Yes,
after the 17th birthday or shortly thereafter.
yes,
And you've heard some of the things that the jury has heard. Yes?
yes.
Okay. What's the name of the first mother of Shelby's first child? What's her name?
Of Shelby's first child?
Yes, the mother of his first
Caitlin.
child.
Caitlin.
Caitlin. I'm
very-
asking it
very
because
nervous
the
also.
jury doesn't know, right?
Caitlin.
So her name is Caitlin?
Okay, yes.
And tell the jury about Caitlin and the daughter that Shelby and Caitlin had. What's her name?
Mackenzie.
And I'm going to show you the jury defense exhibit 54 in evidence. Who's that?
That's Mackenzie.
That's Mackenzie. Did Caitlin and Mackenzie live with you and Lisa for a short time period?
I don't think Mackenzie was born yet,
Okay.
but yes, they lived with us.
Okay. Did you guys take care of Mackenzie after she was born? Do you recall?
I don't recall.
That's
If we-
fine.
If we just had her for a time, I guess that's very possible, but I don't recall.
That's fine. That's fine. Do you consider Mackenzie your granddaughter?
Absolutely, 100%.
Do you still communicate with Mackenzie?
Yes, we do.
Okay. Does Shelby view Mackenzie as his daughter?
Yes,
Does he love Mackenzie?
yes,
They had, Caitlin and Shelby had problems with domestic violence, right?
yes.
And the jury has heard about it. I'm not going to ask you about it at this point. Do they split up shortly after
Very shortly, yeah.
Mackenzie is born? At some point in time, does Caitlin's mother, so the maternal grandmother, end up being the primary custodian of Mackenzie?
Yes,
Okay. And raises her?
yes.
And how far away from your home in Ohio does Mackenzie live?
I believe about 2.5
2.5 hours?
hours.
Okay, all right. But you still communicate with her on a regular
Yes,
basis?
yes.
Okay. Who is the next person that Shelby ends up having a relationship with?
Jamie,
Was that also a very troubling relationship?
yes.
do you recall I'm going to show you Offense Exhibit 57. Oops. What am I doing wrong here? There we go. Who's that?
That's Bella and Oliver.
Who's the oldest?
Bella.
Do you recall being summoned to the hospital shortly after Bella was born?
Summoned to the
Right,
hospital.
meaning you were asked to come to the hospital?
Oh, yes.
Okay. Do you recall any problems?
Wait. Was I directly asked to be, to come?
Did you accompany Lisa to go to the hospital?
Yes.
Okay. And did you and Lisa end up taking Bella back home? Do you recall that? No? If you don't
No.
remember, it's okay.
No, it's not that. The hospital?
Oh, maybe it wasn't the hospital.
Yeah.
Was there an incident where you guys were summoned to come to get Bella?
That is correct.
Okay. Tell the jury about that incident when you were
Sure.
asked to come and get Bella. Where was it?
We were at home sleeping, and it was the middle of the night. It was 3-ish, 4-ish, or something in the middle. Is that what we're talking?
Right.
Okay, I just,
Yeah.
because there,
My
as far
apologies
as the
for confusing
hospital,
you.
the hospital is
That's
not
fine.
involved.
Yeah, I was mistaken.
Okay, that's okay. And the police called our house and asked if we could come pick her up and take her home and make sure that she's safe. Lisa was the one that answered the phone call. I was sleeping. She's waking me up, and then we were summoned.
Okay,
We
right.
showed up right away. We grabbed our stuff and we went right away, and so yeah, we went to the apartment. It was at the apartment.
Was that shortly after Bella was born?
Yeah, like 24 hours.
Right, okay. So she'd been released from the hospital?
Mm-hmm.
Yes?
Yes.
Okay. And within 24 hours or so, you and Lisa are summoned or asked.
There's a crisis already.
It was a
yes.
crisis. Tell the jury about the crisis that was taking place. What do you see when you arrive?
Shelby's complete. He has no shirt on. I don't know if there's a mark or a place on his body where he doesn't have a mark, from his neck to his back, his arms, his torso, even his eye, the white of one of his eyes is completely red. It doesn't make any sense to us. We start asking questions. What's going on? What happened? Because from my recollection, I believe the police had already left. And it was just the three of us, Lisa, myself, and Shelby. So we're asking him questions, and we're being told that she basically jumped all over him, and they were fighting, and those were all marks from her. And
I'm going to show you another photo.
okay.
And this is Offense Exhibit 17.
Yeah.
Were those the type of injuries that you saw?
Yes. I don't know if those are the exact day
Sure, it may not
injuries,
be the
but
same.
it was exactly like that. Yeah, big gouge in his neck and like his eyes. That was the big ones. But yeah, all over his body, his back,
Defense
everywhere.
Exhibit 12. Already in evidence, and I'm going to slide up so we can see. Those type of injuries?
Yes.
Was Jamie there when
No,
you arrived?
No. No, she was not. I believe the police had taken her.
Okay. Do you take... Oliver's not born yet, right?
Correct.
Do you and Lisa take Bella home?
Yes.
How long do you have Bella? What do you do when you get Bella? Do you have to buy clothes for Bella?
Yeah, we had nothing. So we stopped with her, excuse me, and got bottles, formula, diapers, everything we needed. Lisa was, of course, all over what needed to be done. And I, I'm supporting her. So yeah, we're going through this together.
Okay. How long is Bella with you and Lisa before Jamie comes to the house looking for Bella?
I believe it is just the next day.
Okay. Tell the jury about what happens when Jamie comes to the hospital. I mean, not the hospital, I'm sorry.
That's okay.
The hospital happened before all this.
This is at our house.
Right.
So my understanding, from best I can recollect, is that both Jamie and her mother, Laura, are going to be coming to pick up Bella. Assuming it's not gonna be easy, but certainly not gonna be a problem. We're ready for her. We're both there. We're present. And then Jamie gets there and is beating on the door. We let her in. She is extremely aggressive. She grabs Bella immediately from Lisa and is holding Bella with her right arm and is not even paying attention to Bella. And she's waving her arm, and she's extremely unhinged. Her face is red. She's seething. The creases in her mouth are white. There's saliva coming out. And then she goes in spurts of saying whatever she was saying, and then she even has to breathe after she does what she's doing, and then she'll look at Bella. That's kind of what my memory pictures.
Frightening?
Very, very, yeah, absolutely. I mean, I wasn't scared for my life.
No.
Frightening in the fact I was worried about Bella. And I know I was making eye contact with Lisa while she's doing this, trying to figure out, if something goes wrong here, to protecting Bella, or be ready to protect it in case something goes haywire here.
Does Lisa try to calm Jamie down?
Oh, yes, yeah.
All right. At some point, is he able to calm her down a little
No.
bit? Not really? Okay.
She calmed down a tad, but she's still completely breathing heavy. She's still red in the face and very upset.
Does Jamie, her mom, and Bella end up leaving your house?
Yes.
Okay. Would you say that your time when you are having contact with Jamie is sort of a limited time period?
Yes.
Okay. Did you and Lisa try to help Shelby and Jamie get an apartment?
Yes.
Okay. But at some point, what happens? Why don't they just stay in the apartment?
Can I correct my answer on
Yes.
that? I don't know exactly, like, if we pay, or like, I know that we were supportive, like, so whatever we did, we were doing whatever needed to be done.
Sure.
So to answer your question, yes, but
Sure.
it's not like we gave them an apartment.
Right, but you
Okay.
helped them get an apartment. You assisted them in it.
Yes,
And they had an apartment for a period of time in
Yes.
Ohio.
yes.
Okay. Did the relationship between you, Lisa, and Shelby and Jamie become somewhat distant because of the volatile nature of their relationship?
Yeah, well, just after they left, Lisa and I looked at each other like, wow, this is not good. This is really bad. We wanted to be involved and get with Laura to have some kind of communication because of the uncomfortableness we were seeing between the two of them and the safety of Bella.
Did you want them to have a good life?
Yes, of course.
Of course, right. But because of that type of behavior, there's less contact between you and Lisa
Unfortunately.
and Shelby and Jamie, right?
Yes, unfortunately.
Okay. And how old is Alex at this time? Do you recall?
I had to think about that.
When was he born?
He was,
And I know you have a little cheap paper with dates.
I do.
If
May
you
I?
need to pull it out and look at it, it's
I ask you,
okay,
'cause
because this is
when it
not
comes
what you're
to-
used to,
yeah.
right?
I appreciate it.
You don't normally come and testify in court, right?
No.
Have you ever testified before?
No, I have not. It's just like a doodle thing that I was trying to figure things out with dates. Trying to think, this time frame in general. There's so much that had
The
gone on.
the question is, Alex. How old is Alex now?
I'm trying to picture. I don't know why I'm drawing a blank. But I am.
Paul,
Yeah,
just look at me. You don't worry about those
all
numbers.
right.
Look at me and how
I'm
old is,
sorry.
how old is Alex now?
Right now?
Right now.
Oh, I'm sorry.
Yeah.
I thought you meant at
I
that
know,
time.
I'm trying to help you a little bit.
Okay. Yeah.
How old is he now?
He is 25.
25. Okay. So, going back to when this happened, how old is Shelby?
Shelby's 31,
Okay, he's going to be 32 in August?
August 19th.
Do you recall Shelby being 19 when Bella was born?
Yes,
So, that's 13 years ago, right? Roughly?
right.
Okay. And you said Alex is 25?
Yeah.
So, maybe he was 12 at the time?
19.
But you don't, it's okay. If he was 11, 12, 13, it doesn't matter, just roughly. 13 years
Right.
from 25?
Yeah. I apologize.
It's okay, Paul. Do you need a break? Take a deep
I
breath.
can't think
It's
right
okay.
now. I can't think
It's
right
okay.
now.
It's all right.
I'm having a hard time thinking.
It's okay. But he's 25 now, right?
Yes,
Alex is
yes,
25 today.
Yes, yes.
He's married?
He is.
Okay, all right. So would it be fair to say that having those type of activities in your home when you have another young son that you're trying to raise wasn't good,
No,
right?
no, it wasn't.
Okay, all right. Are there times? I tell you what, I'm gonna skip ahead, okay?
Okay.
I'm gonna skip ahead to December.
May I just, all right.
I'm sorry?
I was just gonna say, the problem I'm having is I'm not even picturing Alex at all.
Right?
That he's 12 years old or,
That's fine.
I mean, the amount of focus I have to put in to thinking about Shelby and Bella and all of this and what's happening here. I apologize. That's why honestly, I don't know how.
It's okay.
Okay.
I think the last time you went to court is you took your dad in because he had a parking ticket that
Yeah.
he needed to pay, right? And the judge told you you couldn't speak for him and you had to sit down.
That's correct.
Okay. It's all right. I want to take you to December 2017.
Okay.
Is that a very difficult time period for you? December 2017. As it relates to your son, Alex.
Yes.
Okay? Tell the jury what was happening to Alex in December of 2017.
He was getting very ill, and we didn't know why.
Okay. Was he in the hospital?
He did. He was admitted into the hospital. Well, it was about a month to find out what was wrong, and then, yeah, he was in the hospital for another month.
Okay. All right. So December 2017, January 2018, he's in and out of the hospital, right? Yes?
Yes,
Okay. Ultimately, he's diagnosed with cancer,
correct.
and he's very sick.
Very.
You were concerned that he might die.
Absolutely.
Okay. During that same time period, January 2018, so Alex goes in the hospital in December, so the following month. Do you recall Lisa getting a phone call from Shelby asking for help?
Yes.
And it was not a good time,
No,
right?
correct.
And you didn't know, and Lisa didn't know the extent of what was happening.
Right. Yes.
And so Shelby was told this is not a good time, right?
Yes, he was told this is not a good time.
Your brother is in the hospital, we're afraid he might die.
That's correct.
The following year, Alex goes into remission, what, that summer or the summer of 2018? Or the fall?
It was, I believe it was July.
Okay, we'll ask Lisa.
Okay. I'm really bad with dates.
But fortunately, he goes into remission.
Yes.
And then, I'm going to jump to January of 2019. Do you learn about what Shelby Nealy had done? Is that when you learn about it?
I believe that was the date.
Okay.
I believe so, yes.
Was it when he was arrested?
Yes,
Okay. So when he's arrested, that's the first time you learn
that is correct.
of the horrific things that he did, right?
Yes,
Obviously, you don't approve of that type of behavior.
of course not.
That's not the Shelby Nealy that you know, right?
Not at all.
Okay. But unfortunately, that's what he did, right? Sadly.
Yes.
And did you learn shortly thereafter that Shelby Nealy had confessed to having done this?
Yes.
Okay. Is he still your little boy?
Absolutely.
Will he always be your little boy?
Absolutely. Yes.
During the time that he's been in jail in Florida the past 6 years, have you been able to visit him in person?
No.
You've been able to hug him?
No. Haven't been able to talk to him.
Okay. You talked to him on the phone?
If he called us,
Right, right.
because he didn't have a cell phone, only
Sure, sure. And while he's been in jail, you've had many phone calls with him, right?
Mm-hmm.
Yes?
Yes, every week.
Okay, every week. And those calls are recorded?
Mm-hmm.
Yes?
Yes.
And what do you talk about?
Small talk, what's going on in life with him and with us and our kids, our families, friends, work.
You tell him you love him.
Mm-hmm.
He tells you he loves you.
Correct.
If the jury allows Shelby Nealy, your son, to die in prison of natural causes, is it your hope that you'll be able to go see him in prison?
Yes.
Will you continue to talk to him?
Yes,
And will you continue to love him?
I will.
If I could have a moment. No other questions at this time?
All right. State, I assume you have some cross-examination, is that right? All right, why don't we go ahead and take a 15-minute break, and then we'll come back and we'll do cross-examination, all right? So, jury's out of the hearing. All right, sir, you can take a bathroom break or whatever, and then you'll be back on the stand in 15 minutes, okay? All right, understand? Okay, listen. All right, so we'll see everybody in 15 minutes.
All right.
I think you're doing the cross.
Yes, sir.
All right, everyone is present, including the defendant, and we're going to bring the jury back.
Your Honor, jurors in the jury box and seated.
Welcome back, members of the jury. State, you may proceed with your cross-examination.
Morning, Mr. Swensen. Good morning. Now, there's a couple things that I wanted to bring up with you that were discussed in your direct examination, and I'd like to talk a little bit about your relationship with Mr. Nealy as well.
Okay.
Now, when you were asked about the incident where Jamie came to your residence to get Bella, and she was very upset, you recall talking about that?
Mm-hmm. Yes.
When she was upset, at that time, she was a young mother, and that was her first baby, right?
Correct.
And the reason she was upset is because she wanted to get her baby back, right?
Correct.
Okay.
Yes.
Now, when you came into Shelby Nealy's life, he was a very small child, right?
Yes.
And you provided Mr. Nealy with a good, loving home, right?
Yes.
And in fact, you identified very closely with him because of your own childhood, which you felt was very similar.
Yes.
And after you married his mother, you paid to put Mr. Nealy through private school in elementary school and in the beginning of middle school, right?
Yes.
And eventually he switched over to a charter school, right?
Yes.
And after he switched during the first year, he did very well. I think you said previously that he was top of his class that year, right?
Yes.
So it was important to you and your wife to make sure that Shelby was successful and happy, right?
Yes.
And that was really a priority for the both of you, wasn't it?
It was.
And it's been brought up that you eventually had another child, Alex, who was like 6 or 7 years younger than Shelby, right?
7 years.
7
yes.
years younger, okay.
Yes.
And they got along well, right?
Yes.
As Shelby got older, in his teen years, he became more rebellious and got to where he refused to follow household rules, right?
Yes.
Now, these were all normal rules for a teenager, like being home by 11, right?
Yes.
And his refusal to follow rules extended to his behavior at school, didn't it?
I couldn't hear you.
His refusal to follow rules extended to his behavior at school, right?
Yes.
In fact, when Shelby was in the 11th grade and left school, it was because he was expelled, right?
Yes.
And I believe that was not the first time the school tried to expel Mr. Nealy, right?
Correct.
And when they had done that before, you and your wife had talked to them and talked them into letting him stay and not expelling him, right?
Yes.
And that happened multiple times, right?
No. It happened one time.
One time, and so it was the second time that they expelled him?
No, the first time they wanted to expel him, we went in and asked if we could speak with them. We had a meeting with the principal and the vice principal. And then we together collaborated, and the papers were signed, or the paper, and they said they would hold it and give him another chance.
Okay.
It just
And
happened once.
after they gave him another chance, did his behavior improve?
No.
Okay. And that misbehavior included things like standing up in the middle of class and yelling swear words and arguing with people, right?
Yes.
So during that period, Shelby was doing whatever he wanted, regardless of the rules at school, right?
Yes.
Okay. But despite Mr. Nealy acting out, you and your wife remained supportive of him, right?
Yes.
Okay. And in fact, when he got his high school girlfriend pregnant, you helped Shelby then too, right?
We did.
Okay. And at that time,
Well, we helped both of them.
sure. And originally, she moved in to your house with Shelby, right? And they wanted to have an apartment of their own, didn't they?
Yes.
And you helped with the first month's rent and paying the security deposit, and you even furnished that first apartment for them, didn't you?
Correct.
So you were very supportive of Mr.
Yes.
Nealy. Now, after that first marriage ended, what did Mr. Nealy do with that apartment that you
Can
had
you
furnished?
repeat the question? I'm
What
sorry.
What happened with the first apartment that you helped get for Mr. Nealy and you furnished for Mr. Nealy after his first marriage ended?
We wanted to be a springboard, not a parachute in this situation. We took, and unfortunately, they didn't capitalize on, and there was a lot of talk. It wasn't like we just did things, you know, when we sat down and it was methodical and we explained things. But yeah, unfortunately, they didn't capitalize on the help that we were trying to give them. And ultimately, of course, it didn't work out.
Sure. And Mr. Nealy abandoned the apartment eventually, right?
I believe, yeah, I guess you could say it that way. I don't know if I would put it that way. He didn't just bail.
Well, he did eventually move back into your residence again, right?
Yes.
Okay. And after he moved back in with you and your wife, did Mr. Nealy continue to have problems not following the rules?
Yes.
And isn't it true that during that period, Mr. Nealy would lie a lot to you and your wife?
Yes.
And Mr. Nealy would also leave windows unlocked so his friends could come over at night when they weren't allowed, right?
It was a one-time thing. It wasn't hours of the night. The way that it's been said in here is incorrect. Each time that you've said it, it's been incorrect.
Okay.
It happened one time where he must have left the window unlocked, and it was during the day. We were all leaving. He was supposed to go to do something positive, like go to the library or whatever. We were going to work. He opened the door or the window and went in one time and took advantage of being in there freely while we were all at work. The place
And that
wasn't
was
trashed
against-
or anything like that, but yes, he
That,
did.
and that was against your rules at
Of
the time, right?
course.
And also during that period, items of value started disappearing
Yeah.
from your home, right?
Yes.
And I think you've mentioned that gaming systems, things of that nature would disappear. And at one point, Mr.
Yes.
Nealy even took his own mother's wedding ring, didn't he?
Yes.
Now, isn't it true that the real reason Mr. Nealy stopped staying at your family home and was living in his car because of a lack of trust that his actions created and the fact that he was not allowed to smoke marijuana at the family home?
It was one of the things that we did not want, that we would not accept, him bringing drugs in the house.
And his younger brother was, what, 10 or 11 years old at the time?
That sounds, yeah, I would say that's correct.
And so you didn't want drugs and negative things like that around him
Correct.
either,
A
right?
bad influence on, yeah, his younger brother, 100%.
Sure. And despite all that, you still cared very much for Mr. Nealy,
Yes.
though, right? In fact, after Shelby left for Florida and then came back to Ohio with a new wife that you had never met before, you helped them get a place of their own in Ohio, right?
We helped in every capacity that we could. I don't, like I said, I don't know exactly what we did, but we did everything that was needed to be done that we could do
Sure.
to support.
And you tried to continue being
Yes.
supportive, right?
Yes.
And when things eventually turned sour in that relationship, Mr. Nealy would have been welcome to move back into your home, right?
Specific, can you be more specific? Like, I mean, there's so many times that happened. I mean,
If he and Jamie had divorced, would he have been welcome to come back to your home?
it's a hypothetical.
Sure.
Of course. I mean, as long as there wasn't a threat or a fail of, a trust issue where we, because we still do have a young son in the house.
Sure. But Mr.
Yes.
Nealy didn't choose to do that, right?
He didn't choose to do what?
To leave his wife or to come back to you guys.
Right.
Instead, Mr. Nealy moved back to Florida with his wife Jamie again, right?
Correct.
And after moving to Florida with Jamie, he eventually came back to Ohio in early 2018 without her, right?
Right.
And during that period, you did get to see him, right?
Yes.
And when you saw him, he was happy and smiling, right?
Yes.
So he didn't seem upset about what had happened.
Well, I didn't know what was going on, but I mean, it was small talk. I'm catching up with him. I haven't seen him in a long, long time, so I think he was smiling at me. I was smiling at him, seeing the children. Yeah. So,
He didn't seem stressed at the time, right?
no.
And later, he left again.
Right.
And then in January 2019, you said you spoke with him on the phone after he was in custody for 3 more murders, right?
Can you say that again?
January 19, you spoke with him on the phone again, but at that time, he was in custody for these murders, right?
Yes.
Now, another thing that was discussed on your direct examination was when Mr. Nealy learned about his father's suicide, and that he was very upset about that when he was 17, right? During that time, you and your wife were supportive of Mr. Nealy, right?
Yes,
And you tried to get him therapy to help him,
yes.
and I think he may have also gone on some medication as well.
I believe so. I'm not sure. I think so, though.
And at the time, Mr. Nealy knew why his father had committed suicide, or at least he said he did, right?
No, he didn't know why. No, I don't know if anybody knows why.
Well, didn't you previously say that it was because his father was being chased by the cops? Or was
I
one-
said, I may have said it directly in my deposition that way, I'm not sure. But I do know that that was the understanding I had, I
Sure.
think, is what I think I said.
Yeah, and you knew that because Mr. Nealy had told you that, right?
If I said that, then I apologize, Your Honor, or I don't, it was my recollection of, that was my understanding as time went by, because I was inquiring why did he feel guilty of this fact that his dad, why did he put so much burden on himself for doing this? Or for his father, biological father.
Sure. And at the
Killing
time,
himself.
at the time when he was 17, he indicated why he felt that way, didn't he? And it didn't have
He
anything
said
to do with his stepmom.
When initially, the very first time, to him directly was
Yes.
telling me that he thought he could do something, he could have talked to him through it to not kill himself.
Yes. And
He felt that he had the ability to stop him.
Mr. Nealy felt bad about how he wasn't available to do that for his father because he had shunned his dad for forgetting about his 16th birthday and hadn't talked to him in a year, right?
Well, I don't know I don't know, I think they still talk, but it could have been a year, but there was no doubt a time period where he wasn't going to talk to Bobby because he was very upset with him.
And that's why he indicated when he was 17.
Yeah,
right?
initially that's why he felt that Bobby killed himself, is that Shelby thought it was because he wasn't communicating with him
Right.
anymore.
Nothing further, Your Honor.
Any redirect?
Despite the behavior, the bad behavior that Shelby engaged in his teenage years, and despite the horrific behavior that he engaged in when he killed Jamie, and when he killed Jamie's parents and her brother, he's still your little boy?
Yes,
You still love him?
yes.
You see someone other than the person who did those horrific acts when you think about him?
I don't understand any, it does not even, it does not make any sense to me.
Okay. But you still love him,
I absolutely do.
and you'll continue to
I
love him.
will.
That's all I have.
Thank you. Sir, you may step down. Defense, please call your next witness. Lisa.
Good morning, sir, please, ma'am. Face the clerk, raise your right hand and receive the oath.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? Yes.
This way, please, ma'am. Please watch your steps. Please speak into the microphone loud and clear. Good morning, ma'am.
Good morning.
You may inquire.
Please tell the jury your full name,
Lisa Swensen.
and do you see Shelby Nealy here in the courtroom right now? Can you see him from where you're sitting? Who is that?
That's my son.
Okay. Lisa, I want to go back to your teenage years. And if you ever need a break, just let us know, okay? But I want to go back to your teenage years, the latter teenage years. Your parents divorced when you were about 12?
Yes.
And at some point in your latter teenage years, you meet Bobby.
Yes.
Do you recall, were you about 17 when that happens?
Yes.
Okay. And you become pregnant.
Yes.
And when you're 18 years old, you're pregnant with Shelby Nealy.
Yes.
In April of 1993, do you marry Bobby?
Yes.
How old is he at the time?
Bobby,
Yes.
18.
Okay. Where do you live in April of 1993 when you married Bobby?
We lived with his parents, Bobby's parents.
In what state?
Texas.
And the relationship you had with Bobby, is that a relationship that you've been trying to block out for many years?
Yes.
It was not a good chapter.
It was not a good chapter.
The only good thing for you that came out of that chapter is Shelby Nealy.
Yes.
Did he physically abuse you during your pregnancy?
Yes, he did.
Did he push you?
Yes.
Did he shove you?
Yes.
Do you recall an event that I believe happened maybe at his grandparents' house while you were pregnant? When
Yes,
you
I
were
do.
trying to keep him from driving? Do you recall that?
Yes, Bobby showed up at my dad's house. He was high on something, drunk, on a motorcycle. I did not want him driving that motorcycle home and getting in a wreck and killing himself before he could meet our unborn child. So I decided to drive him home, even though it was not the best choice. On the way to get into my dad's car, I saw a change that made me nervous, that he became aggressive. So I tried to get back into my dad's house. He caught me. He dragged me to the car, threw me in it, and proceeded to get in there, damaging a lot of stuff in my dad's car, hitting me in the side of the head, and I drove him home.
Did you call the police?
The police actually pulled us over, but I was too afraid to tell them what was actually going on. Because I didn't want him to hurt me anymore, or especially hurt our unborn child. So I continued, after we got past the cop, continued to get him back to his parents' house.
Okay. Shelby was born August 19th, 1993?
Yes.
Is that accurate? Okay. So how old is he today?
Shelby is 31.
He'll be 32 next month?
He will be 32.
Okay. After he is born, during the first year of Shelby's life, did the abuse that you received from Bobby continue?
Yes.
Was there a particular moment where you ended up having to crawl through broken glass
Yes, there was.
Tell the jury what happened, what led up to that, and about that event.
Well, Shelby and I were sleeping in bed. I had Shelby right beside me. Bobby showed up at some point in the middle of the night. He just came home. He wanted just wanted to be aggressive. He was high on drugs, I don't know what. Immediately yanked me out of the bed, just yelling and hitting. And then at some point, he wanted to leave. But before he left, we had a glass dining room table. He broke it.
How did he break it?
He just picked it up and threw it down, and it just shattered. And then he couldn't find his keys. So he thought that I did something with them, which I didn't. So therefore, he made me crawl through shattered glass with a gun held to me, trying to find the keys. And I just prayed, please, let me find these keys so I can live another day. And then after that, I got Shelby. I held him to protect him. And then Bobby held a knife to my throat and told me how much of I was not a good person. And I would never find anybody that would love me or care about me. I was worthless. And if he ever found me again, he would kill me, chop me up, and dispose of me.
Did he leave with Shelby that night?
Yes, he did. He made me load him in his car, and then he slashed all my tires so I couldn't try to follow him.
Did you call the police?
Yes, I did.
How old was Shelby at the time?
Shelby was probably 10 months.
Was your mother living in Texas at the time?
No, she actually came down because my nephew was born, so she wanted to be there for the birth of him.
So your mother was in town at the time?
Yes.
Not living with you,
No.
but living with your sister?
She was not living with my sister.
Okay. But your sister is the one that was having the baby?
Yes, my sister was, yes.
Did you ask your mother to help you get Shelby?
Yes, I did.
Okay. How were you able to get Shelby?
Well, I knew Bobby was going to go back to his parents' house, and his grandparents, which lived right next door, took care of Shelby during the day while we worked. And I went over there the next day, my mother and I. They had really, really mean dogs in their yard, which I could have cared less if they attacked me. All I cared about was getting straight to Shelby, which I did. And his grandparents were like, oh, wait, we have to call Bobby. I'm like, no, I just grabbed my baby. He was filthy, dirty. And then I went into hiding.
You knew Bobby wouldn't be there at that time?
Yes.
Okay. And you say you went into hiding. Where did you hide?
With my best friend, her dad was a police officer, so I knew that I'd be safe until we could arrange for me and Shelby to leave Texas.
And your best friend, what was her name?
Kelly.
Kelly what?
Kelly.
Okay. So at some point, after hiding out for a while in Texas, do you, your mom, and Shelby move back to Ohio?
Yes, we did.
Okay. And when you moved back to Ohio, do you live with your mom?
Can I just back up for a minute?
Yes, absolutely.
I never thought I'd leave Texas, ever. I love Texas. Texas was my home. And my dad, he thought that he would never have to see a child of his leave to protect theirself. I remember on the way to the airport, him looking over at me and just saying, I know you don't believe this now, but there is somebody out there that will love you and care for you and protect you. You will find that person. And then he put me on a plane. And I made a new life in Ohio. Sorry.
No, that's okay. So in Ohio, I don't need the address, but what city in Ohio did you move to initially?
Initially, when I moved to Ohio, it was Lorain.
Lorain, Ohio?
Yes,
And who lived in Lorain, Ohio?
my mom and my
Anyone-
grandmother.
Your mother and grandmother?
Mm-hmm.
We've seen the name Rose
Mm-hmm.
in some of the paperwork, and what's the name Rose?
That's my maiden name.
Okay, it's your maiden name?
Yes,
All right. So your mother, her last name was Rose. Her married name would have been
her
Rose.
married name.
Okay,
Yeah.
all right. So for the first several years in Ohio, does your mother help care for Shelby while you were working?
Yes, she did.
Okay, do you live in a small apartment together?
Yes, we did.
At some point, do you move out on your own?
Yes,
You-
I did.
You and Shelby?
Yes.
But did your mother continue to help out with Shelby as far as,
Yes, while I stayed in Lorain, yes, she took care of him.
all right. Did you end up getting in a relationship with another man?
Yes,
What was his name?
Danny.
And did that relationship last?
No,
Why not?
because I could see some of the same characteristics and similarities that I dealt with in the past with
With Bob.
Bobby, and I was not going to allow that
Okay.
type of behavior.
So wasn't any physical abuse?
No, no physical, but mental, and I wasn't going to let it get too physical.
Okay. During this time period, the first 3 years of Shelby's life, was he comfortable around men?
No, he was definitely terrified of men.
Okay. At some point, do you meet Paul Swensen?
Yes, I do.
Okay. Am I pronouncing that correctly? Swensen?
Yes.
Okay. Scandinavian?
Yes.
Okay. And you fall in love with him fairly quickly?
Yes. Yes, we did.
All right. And he meets Shelby fairly quickly?
Yes.
Okay. And how old was Shelby at that time?
Shelby was 3.
Okay. So roughly 29 years ago.
Roughly, yes.
Okay. Do you end up moving in with Paul Swensen?
Yes, we did move in together.
All right. And in fact, the majority of the time that you've been together, have you lived in the same home?
Yes.
And you don't have to give the address, but what's the city? where
Parma.
this- Parma,
Parma.
Ohio? Okay. Is it a modest home?
Yes.
But it's
I
your
think
home?
It's our home.
Okay. And that's where you brought up your family?
Yes.
First, it was just you, Paul, and Shelby.
Yes.
How would you describe Shelby during those toddler years up until his teenage years?
Very active.
Okay?
Had to chase him around.
Okay.
Matter of fact, my father-in-law used to joke, is his name Shelby or no Shelby?
Okay. Did people suggest to you that you should have him evaluated to see whether or not he suffered from ADHD?
Yes, once he reached the school age,
Okay. Did you resist that initially?
yes. I did not want him on medication.
Okay. For several years?
Yes,
Okay. At some point, do you end up having a doctor prescribe medicine for his ADHD?
yes.
Okay, to try to basically calm him down a little bit?
Calm him down, help him focus in school.
Okay, all right. In retrospect, do you wish you had put him on medication much earlier?
Yes,
Okay. You have another son, Alex.
yes,
Okay. Did he also have problems with ADHD?
yes, he did. And I actually put him on medicine when he started first grade.
Okay.
Yes, a lot sooner.
All right. He's 25 now?
He will be 25
Okay.
in September.
All right. And he's doing well?
Yes, he's doing well.
You've heard testimony about the volatile relationships that Shelby was involved in and a
Yes.
participant in.
Yes,
From the relationship with Caitlin
yes,
that produced his daughter. What's his
Yes.
daughter's name?
Mackenzie.
Mackenzie. To his relationship with Jamie,
Yes,
which produced 2 children.
Bella and Oliver.
Okay. And you've heard testimony about times that Shelby was homeless.
I've heard it.
Okay. Generally, was he welcome to your home?
Yes, he was.
Okay. Were there times, however, because you needed to protect your family, that if he didn't follow rules and do, as you and Paul, just reasonable rules that parents impose, that you said, you can't be here if you're not going to follow rules?
Exactly. And if the roles were reversed and his brother was out of line, the same thing would have happened to protect him.
Sure, sure. Unfortunately, Shelby had difficulties even with those parameters following.
Yes, he did.
Okay. And during the first relationship, was there a time when Shelby and Caitlin lived with you?
Yes, for a short period of time.
Okay. And was that after Caitlin was pregnant?
Yes.
Okay. What happened after she gave birth? After Caitlin, were they living with you after?
No, they were not living with us after after Mackenzie was born. They were in their own apartment.
Okay.
Yes.
Okay. So, was there a time, however, that Mackenzie was living with you guys, or you were helping raise Mackenzie?
Mackenzie has never lived with us,
Okay.
and we've never helped raise her.
Okay.
But when she was born, I went to be with her every second.
Okay.
I love my granddaughter very much.
Okay.
And so Caitlin was more than willing to let me have her at any point in time. So she was, I had her a lot.
Okay.
A lot.
Would it be fair to say, and we've heard evidence in this trial, that both Caitlin and Shelby struggled with behaving?
Yes.
They were engaging in conduct that you did not approve of.
Yes.
Unfortunate conduct.
Yes.
At some point, because of that, Mackenzie ends up being raised by her grandmother, maternal grandmother.
Yes.
And you've heard testimony that there was a time period where Shelby indicated that he was not Mackenzie's father. You heard that?
I've heard that.
Okay. Does Shelby acknowledge that he is Mackenzie's father?
Yes.
Have you always been Mackenzie's grandmother to her?
Yes.
To this day?
Yes.
And Mackenzie knows you as her grandmother?
Yes, she knows me as Grandma.
Grandma. Okay.
Grandma.
All right. While Shelby has been incarcerated, has he written letters to you to hold for Mackenzie to give to her after she's 18 years of age?
Yes.
Do you recall all the details of what's written in the letter?
No, I don't.
Generally.
General, that he loves her
Okay.
and that he's sorry that, he can't be in her life.
Okay.
But I can't tell you word for word.
Sure. But generally, he loves her and he's sorry.
Yes.
Okay. Shortly after he's arrested, he when he's first arrested in Ohio, did you talk to him and meet with him in Ohio?
He called me on the phone.
Okay. Does he tell you that he's done a horrible thing?
Yes, he did.
Confesses to you horrific crimes?
Yes, he did.
Okay. Did it break your heart?
Yes, yes.
Okay. But he's your little boy,
Yes,
always will be.
yes.
Did you continue to have conversations with him on the jail phone?
Yes.
I want to talk about a particular conversation that you had with him in March of 2019.
Okay.
That's fairly close to the time when he arrived in Florida, right?
Yes,
Here at the Pinellas County Jail.
yes.
Do you recall talking to him about where he is being housed at the Pinellas County Jail?
In a private, I want to say private, a cell by itself.
Okay, okay. And does he tell you he's okay? Like he's safe?
Yes,
That's a mother's concern, right, when you're in jail?
of course.
Not when you're in jail, but when
Well,
your
yeah, not- yeah,
son is in jail.
right, yes.
Okay. Does he tell you that one day he's going to be a famous author?
Yes,
And whatever money he makes, could be millions, right?
Mm-hmm.
Yes?
yes,
He'll give it to you.
yes, he said that.
Does he tell you that, you kind of question him about that a little bit? Do you recall?
I don't recall
That's fine.
me questioning him.
Okay. But does he tell you that part of the reason why he might be successful is because, unfortunately, he's part of an infamous case,
Yes, yes,
facing the death penalty,
yes,
possibly will end up on death row,
yes,
and that might contribute to the book being successful?
yes.
Is that the first time in Shelby's life that he talked about wanting to be an author?
No,
Okay. Tell the jury, about that.
when Shelby was a teenager, he loved to read books. He was passionate about reading books. And That was always a dream to maybe one day write a book and become a famous author.
Okay, all right. You learned recently that he has in fact self-published a book.
Yes,
You can get it on Amazon, right?
yes.
And that doesn't mean a publisher read a manuscript and said, this is great, and we're gonna fund this, right?
Right,
It's self-published.
exactly.
Okay. Do you have a copy of the book?
I do.
Okay. Do you prefer books that are read to you, like Audible?
Yes, I
type?
do. I like audiobooks.
Okay,
Because if I pick up a book and try to read it, I'll just fall right to sleep.
okay,
And I have too many other things that I do that takes up my time.
okay. Would it be fair to say that the book, based on what you've been reading so far, not necessarily your cup of tea?
It's not my cup of tea.
Okay, all
And
right.
I'm sorry to say that.
But you're still,
But I'm proud of the fact that he actually could do that.
right,
Yeah. And maybe one day I'll actually pick up the book and flip through each page and try not to fall asleep.
I want to go through some photos with you that are already in evidence. And so I'm going to step over here with the court's permission. This is Defense Exhibit 34. What are we looking at here?
That is our shed at home.
Is that a shed that, during the period of time when Shelby was having difficulties following the rules at home, that you and Paul actually set that up with a place for him to sleep?
Yes, but it did not look like that.
Right,
It was brand new,
right,
and it was not meant to be a forever thing.
sure.
And I'm going to just put a side note in here. If you ever go camping and you rent a place of theirs, like a little cabin, a lot of times it looks like a shed.
Okay.
So, but to answer your question, yes, he did stay in a shed for maybe a night or two, maybe 3 nights, I don't know.
Okay,
But hey, it's better than, I guess, if he's not going to follow the rules, I guess it's better than nothing.
absolutely. And it had a bed in it at the time, right?
It looked like a mini apartment.
Okay. But that's the same shed?
Yes, it is.
Okay. I'm going to show you Defense Exhibit 37. Let me, can I? There. What is that?
That is a card that Shelby has sent to me since he's been in jail.
Do you know if that's the card that he made?
He said that somebody else did the little hearts and stuff, but ultimately, I mean, it's what he made.
Okay, so it was his card,
Yes,
someone else made it for him,
yes,
okay? And he sent it to you for Valentine's Day.
yes.
And does it still hang in your home?
It is still in his old bedroom that he used to, that was his when he lived at home.
Okay. I'm going to show you Defense Exhibit 33. What are we looking at here?
I believe that's a birthday card he sent me.
So it says, dearest mother, your thoughtfulness is greatly appreciated. Thank you for all that you do for me. I'm blessed to have you. I love you. Love Shelby.
Okay. Yeah, because at first we could send cards back and forth. Now those chew marks are from our cats, so.
Those are from the cats.
Yes. One of our cats loves paper and boxes and stuff, and she was able to get a hold of that, unfortunately.
But despite the fact that the cat got a hold of it, it's still one of your treasures?
It's still a treasure of mine.
Okay. I'm going to show you Defense Exhibit 31. What is this?
Oh, that's, Shelby sent me that as well, since he's been in jail.
It's what?
Shelby sent me that as well, since he's been in jail.
Okay. And it says Love Shelby on it?
Yes.
I'm going to show you Defense Exhibit 36. Who do we see in this photo?
Shelby, Alex, me, and Paul.
Alex is what, 7 years younger than Shelby?
Yes, he is.
Quite a bit bigger than Shelby.
Yes, he is.
Shelby was always a little boy?
Yes, he was.
Let me show you Defense Exhibit 35. Who's in this photo?
That is Paul, Kirsten, which is Paul's sister, me, and Shelby.
Okay. How old was Shelby at the time, do you know?
Oof. 5 or 6, maybe 6.
I'm going to show you Defense Exhibit 50. Who's the young lady in that photo?
That's me. With Shelby.
I'll show you Defense Exhibit 28.
Paul, me, Shelby, and Alex after we brought him home from the hospital.
Sure, Defense Exhibit 29.
Me and Shelby.
Where's
That was
photo?
that was at baseball Indians game in Ohio. That was a day after Paul's sister got married, his sister Sarah.
How old is Shelby in that photo?
Oof. Maybe 19, I'm not sure, 18, I'm not sure.
Okay. It's not during the time period when he came back.
Oh, no.
And when me finish.
Oh, sorry.
It's not during the time period when he came back after having killed Jamie.
No.
Did you have a lot of contact with him during that time period?
Not really.
Right. And is part of the reason for that because this is Alex and Shelby, right?
Yes.
And just for the record, that's Exhibit 32. Was part of the reason why you didn't have a lot of contact with Shelby when he came back after he had killed Jamie? Obviously, you didn't know he killed Jamie.
No.
He didn't
Of
tell you
course.
he killed Jamie.
No.
But is part of the reason for that you were dealing with Alex's illness at that time?
Yes, yes, definitely.
Okay. Do you recall when Alex went to the hospital?
Alex, we checked him into the hospital December 2017, at the end of December.
Okay. And it took a little while to figure out what was wrong with him, right?
Yes, we were in there a complete month before they figured things out. He was already very sick when we entered the hospital. And then after that, we were there 7 months.
7 months after that?
7 months.
Do you recall getting a call from Shelby early in January of 2018?
Yes,
So maybe within less than a month of when Alex goes in the hospital.
right.
Is he asking for help?
Yes,
Is it your thought that he's doing the same old nonsense?
yes.
And at the same time, you're dealing with, I mean, did you have any thoughts that he had killed someone?
No,
Okay. But you're thinking maybe he's involved in domestic violence and not that kind of nonsense?
right. And I told him that he needed to figure it out, that him and Jamie have been and their arguments so many times, and both myself and my husband tried to get him to leave this relationship.
Sure, sure.
So I was fed up kind of at that point. Plus, I had a child fighting for their life in the hospital.
Right, right. So let's go back a little bit from that point. You just told the jury that you had been wanting Shelby to leave the relationship that he was in with Jamie. Elaborate
Yes.
on that. What is it that you saw? What is it that you witnessed about that relationship that brought you to have those feelings when he calls you in January of 2018?
Well, to step back a little bit,
Right,
Bella was less than 48 hours old. The cops called us in the middle of the night, wanted us to come pick her up. And we get there, the cops weren't there. They already took Jamie to the hospital. Shelby, so I didn't see her at first, but Shelby was completely marked from what I could see from head to toe. I was coughing a lot while I was in their apartment, and I'm like, what is this? Well, it was pepper spray, because pepper spray was being sprayed with a newborn baby in there. So I was very concerned about Bella, and the apartment was trashed, just trashed. And I got Bella, she had no clothes on. And we told Shelby, you know, we were called, we need to take her with us for now. I'm sure she's gonna come back, but we need to take her for now. Went to the store, got her formula, diapers, and then I had old outfits of Mackenzie from when she was a baby that I put on her, got her comfortable, fed her, and just took care of her. I didn't know how long she was gonna be there.
okay. You've seen photos that's been presented and introduced into evidence in this courtroom of injuries, scratches, and cuts on
Yes.
Shelby.
Yes,
Were those the type of injuries that you saw on him
yes,
that day?
that particular day, yes.
Okay, all right. And so, and this is just like a day after?
That's just less than 48 hours. Bella was less than 48 hours old.
Okay.
At
So
that
they-
point.
So they've just been released from the hospital?
Exactly.
Okay. And so you take Bella, you get diapers, you get formula, you have old clothes from Mackenzie.
Yes.
You're caring for her, you're loving her.
Yes.
What happens the next day?
Well, it wasn't the next day, it was actually hours later.
Okay,
It was the same day.
same day.
Same day. Jamie showed up very hysterical, very uncontrollable. Came into her house screaming at me, trying to get Bella. At first, I was trying to calm her down. I didn't want anything happening to Bella. And then she snatched her from me, and then I just tried to continue to just try to calm her down.
Did,
And then she eventually,
let me
I'm
ask
sorry.
you, to stop you for a second. Did you see any injuries
no,
on Jamie?
I did not.
No scratches, no cuts, no black eyes,
No,
nothing like what we saw in the photos of Shelby?
no.
Okay. Carry on, what else happens?
After a period of time, kind of got her somewhat calmed down, I guess you could say. And then she left with her mom.
Mr. Doig, when he questioned Paul, your husband,
Yes,
indicated she just wanted her child.
yes, she just wanted her child.
Okay, well, did she behave in the kind of manner that gives you comfort to give?
No, she did not. No, I would never have done that,
Okay,
because we are her grandparents, and I would hope that if I was ever in a situation like that, which I was not, I would hope that the police would call my child's grandparents, and I know that my baby would have been taken care of. She was gonna get her back. There's no reason to lash out like that.
Right. In fact, if the behavior was more calm and hey,
I was thinking she was gonna come in and thank me for watching over Bella and keeping her safe and protected until she could come back for her, but that didn't happen.
That didn't happen.
No.
Okay. I'm gonna show you some other photos. This is Defense Exhibit 49. Who's in this photo?
Our son Alex, Shelby, Paul's mom, Beth, Paul, me, Kirsten, Sarah, and at the time, Sarah's husband, Justin.
And Kristen and Sarah are Paul's sisters.
Yes, they are.
Shelby's aunts.
Yes.
I'm going to show you Defense Exhibit 47. We know who Santa Claus is, but who are the other two people in that photo?
Shelby and Alex.
I'm going to show you Defense Exhibit 40. Who's in that photo?
Shelby and Mackenzie.
And I'm going to show you Defense Exhibit 46. Who's in that?
Me and Joey.
How old were you at the time?
18.
During the 6 years that Shelby has been incarcerated here at the Pinellas County Jail, have you had a chance to meet him face to face in person?
No.
Okay. Have you had an opportunity to talk to him without it being recorded?
No.
Okay. The, when he calls you, it's recorded, right?
Yes.
Okay. Do you communicate with him on a regular basis?
Yes, I do.
Okay. Tell the jury about your relationship with Shelby and how it's evolved during the time that he's been incarcerated.
I just feel like we have had a really good relationship since he's been in. I mean, we talk every week, so it's been good. I definitely just have felt that he's matured since he's been here. I know I even said this at one point to somebody that, and I don't want him, no mother would ever want their son to be in jail, but I almost feel like our relationship's even better than it was when he wasn't. But like I said, I'm not saying nobody wants their son in jail, but I understand why.
But you understand why he's in jail?
Yes, I do understand that.
And based on what he did, you agree that he should be in jail?
Yes.
Okay. But you want to continue to have a relationship with him?
I do.
Okay. You think that your relationship with him has actually improved while he's been in jail?
Yes.
Does he seem to care about what's happening with others?
Yes, he does.
Your mother, is she still alive?
My mother?
Yes.
Yes.
His grandmother, right?
Yes.
What's her name?
Jane,
Last name?
Rose,
Okay. And Jane Rose lives in
in
Texas?
Texas with my sister.
All right. In Magnolia, Texas?
Yes.
Okay. Does he ask about, what about your father? Is he alive?
Yes, he lives in Texas as well, and
Okay.
he does ask me about my father.
Okay. He's not very healthy right now, is that?
No, he's been going through some health things. I went down to Texas in May to see him. Actually, Shelby got to talk to him.
Does he ask about other family members and friends?
Yes.
Okay. And do you tell him about them?
Yes.
And does he seem to care about
Oh,
how
yes.
they're doing?
Oh, yes.
Okay. Does he tell you that he loves you?
Yes, he does.
Do you tell him that you love him?
Yes, I do.
And will you continue to do so?
I will.
Okay. Have one moment, Your Honor. No other questions, John?
Thank you. Cross-examination.
Yes, sir. Good afternoon, Ms. Swensen.
Good afternoon.
Now, you testified that you were the victim of domestic violence in your first marriage.
Yes.
Right? And that was to Mr. Nealy's father?
Yes.
And that violence was never targeted towards Shelby, right?
No.
You love your son, Shelby, right?
Yes.
And you didn't want anything bad to happen with him in Texas, right?
That's right.
And you don't want that now either, right?
I do not.
So that wasn't an environment that you wanted Shelby growing up in, right?
No.
So you left that abusive marriage when Shelby was 10 or 11 months old and moved to Ohio, right?
Yes.
And then Shelby didn't see his biological father again until he was 15,
Yes.
right? So it'd be true then that Shelby wouldn't have had any memory of the domestic violence, right?
Correct.
And he was raised in a normal, loving home in Ohio, right?
Yes.
And Shelby had a good childhood with you?
Yes.
And after you left Bobby Nealy, Shelby enjoyed spending time around your father as a baby, right?
Yes.
And when you remarried to Paul Swensen, Shelby was still very young, and Paul took the role as father figure, right?
Yes.
And Shelby enjoyed spending time with him as well, right?
Yes.
And you observed that your husband, your second husband, Paul, was a loving and attentive father to him as well, right?
Yes.
And you observed that Shelby and Paul had a good relationship.
Yes.
In fact, Paul treated Shelby like his own son, didn't he?
Yes, he did.
You and Paul actually put Shelby in private school and elementary school, right?
Yes.
And then also private school at the beginning of middle school, but then it switched to a charter for the rest of middle and then high school, right?
Yes.
And despite that support, Shelby struggled with his grades in school over time, especially later in his school career, right?
Yes.
When he started to struggle in elementary school and you became aware that he might have ADHD, you did eventually get him on medication for it, right?
Yes.
And that was because his education and growth were priorities for you, right?
Can you repeat that?
His education and his growth was a priority for you,
Yes.
right? Okay. Now, after meeting his biological father, you've mentioned that things went downhill for Shelby, right?
Yes.
But his grades had already been declining prior to that, right?
Yes.
And Shelby had started to hang out with a rough crowd, and you believed he was dabbling in drugs in high school, right?
Yes.
And you had issues with Shelby being lazy and not wanting to do things, right?
Yes.
And Shelby wouldn't follow the rules at school or at home, right?
Correct.
In fact, you had to plead with the school to allow Shelby to keep attending despite the fact that he refused to follow the rules, right?
Yes.
And you had issues with Shelby lying about all sorts of things, right?
Yes.
And in fact, Shelby would lie frequently to get out of trouble, right?
Yes.
You mentioned that eventually he got his high school girlfriend pregnant, right?
Yes.
But that didn't stop you and your husband from being supportive of Shelby, right?
Correct.
And in fact, you helped Shelby's pregnant girlfriend get emancipated, right?
Yes.
And you helped them get an apartment together, right?
Yes.
And not only did you help them get that apartment, you actually fully furnished it for them, right?
Correct.
So you were still extremely supportive of Shelby despite the issues he was having, right?
Yes.
But ultimately, that first relationship failed, right?
Yes.
But that was after Shelby had been arrested for domestic violence against the mother of his first child, right?
Correct.
And they just essentially abandoned the apartment that you had paid for and furnished at that point, right?
Yes.
Despite all that, Shelby was still welcome back in your home at that point, right?
Yes.
And in fact, all he needed to do was to not do drugs or create chaos or steal things in the home to stay there, right?
Correct.
But Shelby would not follow those rules, right?
Correct.
And from there, Shelby chose to live a rough life with a rough group of people at that period of time, right?
Yes.
And that was the time frame where Shelby went to the hospital for head injury in 2012, right?
Yes.
Okay. And eventually, Shelby moved down to Florida and married his second wife, Jamie Ivancic, right?
Yes.
And isn't it true that you had never met Jamie before they were married and she was pregnant?
Correct.
And despite his past problems, you still wanted to help Shelby, right?
Correct.
And you and your husband helped Shelby and Jamie move into an apartment in Ohio, right?
Correct.
And through your contact with them, it was clear to you that they were in a very toxic relationship, right?
Yes.
And during that period of time, you know that Shelby checked himself into a psychiatric facility just to get a break from the stress of the situation, right?
Yes.
So that was not for a real psychiatric emergency, right?
No.
And you encouraged him to leave the situation, right?
Many, many times.
And you even begged Shelby to end the relationship and move back home with you, right?
Many times.
So he knew he would be welcome there, right?
Yes.
But he chose not to do that, right?
That was his decision. Yes, he chose not to do that.
And instead, Shelby moved back to Florida with Jamie, right?
Yes.
And then eventually, Shelby came back to Ohio without Jamie, right?
Correct.
And you didn't know what he had done at the time, but you now know that when you saw him, it was after he had killed his second wife, Jamie, right?
Correct.
And you mentioned on direct that he had asked for some help. I believe that the help he was asking for was for you to watch his kids, right?
For me to, if he felt like they were going to blame him for their argument or whatever, and that if we could take the kids, that's what he said.
Okay. And he told you that Jamie was in a psych ward at the time, right?
Yes.
And you know now that was not true, right?
Correct.
And he seemed fine at the time, right?
Yes.
He didn't seem stressed to you about what he had done and was calm, right?
Yes.
And when he told you that Jamie was in a psych ward, it was easy for you to believe because you knew Jamie suffered from mental illness, right?
Yes.
And eventually, after 3 more murders, your son was eventually arrested in Ohio, right?
Yes.
And he called you from the jail to tell you he was in custody, right?
Yes.
And isn't it true that initially you didn't believe him when he told you that it was for murder?
I did not.
And in fact, you told him that he was lying, right?
Correct.
And that's because Shelby had lied to you very often, right?
Correct.
And you knew that Shelby lies to get out of trouble, right?
Correct.
Now, you recall communicating with Shelby via Facebook Messenger while he was supposedly in Texas, right?
Correct. I would have to, sure, yeah.
And do you recall on December 12th of 2018, Facebook messages from him saying that he was in Texas?
Yes.
Okay. And do you also remember on that date, December 12th, 2018, that he said that he had gotten a new car?
Yes.
In fact, he said he never felt more like you because you liked to get new cars or something of that nature, right?
I love cars, yes.
And that was 2 to 3 days before he murdered the Ivancics, right?
Correct.
Now, you've also spoken with your son multiple times since he's been in custody, and I know on direct, defense counsel asked you about a conversation where he talked about becoming an author and a millionaire, and you spoke a little bit to that on direct, right?
Yes.
Now, isn't it true that the exact words that he said to you were, well, considering I'm all over the news all the time, it wouldn't be hard. Hey, it's a book by that dude. Oh, I have to get it just because I'm curious. Yeah, I know. And then they read it and they're like, oh, wow, this is actually like pretty good. Maybe we shouldn't kill this dude, you know? That's the hope and the dream. Do you recall that?
From what he told me, the phone call?
Yes.
Sure, if that's what it's saying, then yes.
Okay. And you said that he's matured a lot since he's been in custody, right?
I feel like he has. I mean, not at first, of course, but over the years.
It's a little late for that, isn't it?
It is a little late for that.
Nothing further, Your Honor.
Thank you. Redirect.
During that same phone call, March of 2019, do you also recall him, Shelby, saying to you he only has 2 options? One option is to rehab himself. The other one is to do the same old shit. Remember him saying that?
Yes.
Remember him going on to say, I may not get another chance, but at least I did something for me and feel like I'm accomplishing something in my life.
Yes.
Okay. While you've spoken with Shelby over the past 6 years, has he made it very clear to you that he will never, ever get out of prison?
Yes.
He will die in prison.
Yes, he will.
The only way that he will get out of prison is in a pine coffin.
Yes.
But regardless of those circumstances, he's your little boy.
Yes.
You love him,
Yes.
and you'll continue to love him.
Yes, I will.
Thank you.
Thank you. Ma'am, you may sit down. What says the defense?
The defense rests, Your Honor.
State, do you plan on calling any rebuttal witnesses? No, Judge. All right, members of the jury, I guess you'll have a little treat today because the most efficient way to deal with your time, and in this case, is for us to let you go for today, and then we'll come back tomorrow. The reason for that is because now we have legal issues to deal with, and we are going to have to draft the jury instructions for you, and then we're going to have to get them copied and all of that. So by the time we're done with that, it's going to be pretty late today. So the most efficient use for your time is for you to come back tomorrow. And I'll Luckily, it's not raining right now, which is unusual. So maybe things are working out well for me. I do have a motion calendar tomorrow. Fridays are more extensive, so hopefully I'll be done at 10, so I'll ask you to come back at 10 o'clock. What'll happen tomorrow is the lawyers will give their closing arguments. The defense will go first, then the state, the state will go first and then the defense. And then I will read the jury instructions to you, and then you'll go back and deliver. And obviously you have to reach a verdict for all three of the victims. We'll go over all that tomorrow. And anyone have any questions about anything at this point? All right. So again, enjoy the day. Don't read anything about the case, or listen to anything about the case, and we'll see you tomorrow at 10. All right? Thank you.
Please leave the notepads and pens on the chair. Your Honor, the jury's out of here in the court.
All right. How long do the lawyers want for lunch?
Your Honor, normally I would say let's just keep doing it, but Judge Beach is having his 95th birthday lunch at Reuben Icott Center, and I was wanting to maybe make an appearance there if I could. But I mean, that wouldn't take long, but I would ask for at least an hour, maybe an hour and a half. But whatever, if I don't make it, I don't make it.
All right. Well, we'll let you go. I mean, we can
I could be back within like even 45 minutes if you wanted me to.
All right. So we can take an hour for lunch.
Okay.
I mean, we could do an hour and 10 minutes if you want, just so you can eat more. All right. All right, so let's take an hour and 10 minutes, and then we'll go over the jury instructions. I know that the defense has some proposed jury instructions. We'll go over those. Obviously, we'll go over what you want listed as mitigating circumstances. Do you have the list all typed up yet?
We do, but
We need to make a few
modifications.
additions.
All
But
right.
it's pretty much done, so we'll.
All right. How many do you have so far?
We're still finalizing the number. Rosalie says 36, we say closer to 30, but we'll finalize it.
Okay. All right, anything from the state at this point? All right, so we'll see you in an hour and 10 minutes, okay?
All right. Circuit Court's now back in session.
All right, you may be seated. All right, so everyone's here, as far as I can tell. All right, so do we want to do your proposed jury instructions first, Ms. Allaby?
Judge, prior to that, we had the opportunity to do some research over lunch so that I could make sure that this was correct. And I am going to cite to the court Urban versus State at 713 7th 2nd 411, Florida Supreme Court 1998, and Card versus State at 803 7th 2nd 613, Florida Supreme Court 2001, in moving for a mistrial. And the reason for that, Judge, would be is the state cross-examining Dr. Banasco, or Mr. Banasco, on the Ramirez case, and in fact, I will quote from both.
What are those sites again?
Urban is URBIN, 714 7th 2nd 411
Okay.
at 420, and that's Florida 1998. And Card versus State 803 7th 2nd 613, Florida 2001.
Okay.
Judge, the pertinent parts of those cases are as follows, and I'm quoting from Urban. First and foremost, we are particularly concerned that the prosecutor invited the jury to disregard the law. Urban argues that the prosecutor improperly asserted that if Urban was sentenced to life in prison, he could still be released someday. Because, quote, we all know in the past laws have changed, and we all know that in the future laws can change, end quote. We find this to be particularly egregious because it invites a jury to disregard the law as it is written by the legislature. The obvious intent of the legislature in establishing this sentencing scheme was to prohibit parole for the covered offenses, period. By his specious comment that, quote, we all know that in the future laws can change, end quote, the prosecutor invited the jury to disregard this law. In effect, the prosecutor encouraged the jury to reject the only lawful alternative to the death penalty, even if they believed that to be the right recommendation, based on a reflexive fear that, regardless of the law, Urban might someday be eligible for parole. We find this exhortation of particular concern because it is advanced by the state, obviously the same state that has mandated the, quote, no parole, end quote, life sentence alternative. This type of, quote, ignore the law, end quote, argument has absolutely no place in a trial, especially when asserted by the state. And Judge, in that case, the Urban was not reversed, but it was remanded for the imposition of a life sentence due to this error. If the, well, I'm getting there.
Okay.
And Judge, the Card case, in the Card case, that goes to the right to a curative instruction. I don't think that there's any bell here that's been rung that can be unrung, and so that's why we're asking for the mistrial. If the court is not inclined to grant a mistrial, then we're asking for a curative instruction. And in Card, the court said the prosecutor argued that the jury should not recommend a life sentence because there was no guarantee that Card actually would be imprisoned for life, stating, quote, and there is nobody that can say that life is going, that he is going to serve a life sentence. No one can guarantee you that. No one can predict that, end quote. Defense counsel objected, moved for a mistrial. The trial court denied the motion for a mistrial, but sustained the objection and provided jurors with a curative instruction, informing them to disregard the prosecutor's comments, and that, quote, there is no parole, there is no early release from the sentence on a life sentence. In addition, the jurors were instructed that life without the possibility of parole meant life, natural life of a person, and no parole. And that's citing to the Card case. And what we have actually here in this case, Judge, which makes it really more egregious, is it's not just argument that I anticipate would be forthcoming tomorrow, but it was actually elicited testimony in this case. And when we approached the bench, because that was problematic, Mr. Sarabia told this court that there were two that there were two victims, and Mr. Ramirez raped, I don't know if it was another victim or one of those victims, and after consultation with Ms. Deliberato, who was actually on that case against Mr. Sarabia, she informed me that that in fact was not the facts of that case. So we also have cumulative error because...
Well, that was a discussion up here at the bench that the jury never heard.
I understand that, but my point is he was, I'd say, not being forthright with the court. And there's cumulative error here because Mr. Sarabia asked Ms. Deliberato on her cross-examination about David Duclos, and he was on death row and killed 2 people, and she had a tattoo, which she did not have a tattoo. In fact, I believe he later apologized to her for asking that because he got bad information. And then he asked her, so if he's willing to help you in hurricanes, I guess you'd give him a hammer so he could help you fix your roof. This is all cumulative error that's also, by the way, in my opinion, and I think according to the case law, unethical conduct, and I think that the court should grant a mistrial in this case.
All right, well, I will give a curative instruction about the life sentence will be for life and there will be no parole. And he did get out the fact that that other case, I thought that was a Jacksonville case. Didn't somebody say it was a Jacksonville case?
He said he's roaming the streets of Jacksonville now. That's what he said.
Okay. Okay. And then, Mr. Brunman, I did bring out that that was a juvenile and the laws change on the juveniles. But I'll go ahead and tell them that life means life. If that's what they choose, there's no possibility of parole, and that's not going to change. So,
Well, Judge, I would ask you to actually instruct the jurors, like in conformity with CARD, that they are to disregard the prosecutor's comments and that there is no parole, there is no early release from the sentence of a life sentence, and that life without the possibility of parole meant life, natural life of a person, and no parole. All of those things in conformity with CARD.
all right, well, it wasn't a comment, it was a question, and that question was a long time ago. So I can say, do you remember when this happened way back when? Earlier this morning? Please disregard that. If you had asked me that, I would have done it right away because that's very effective where they hear it and then you say, please disregard that last remark. I mean, that's the way I would have done it. Do you really want me to go over it? Like, do you remember when the state asked this question about Ramirez and blah, 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 and they just hear it again? I would be more inclined, under the circumstances, to say that life means life, it's without the possibility of parole, and that law is not going to change. So anything that you may have heard during the trial which may imply that the law could change is incorrect, and you are to disregard that. So I can do that.
That's fine.
Okay.
And Judge, I think it is of value to put on the record. They asked the question. They asked the question of the expert that the only possibility of him getting out was in a pine box.
That's the state of the law.
That's the state of the law.
They invited, we all know that the state of the law includes, and the law has changed since the cases that they cite, where now the legislature can change sentences from the legislature if they want, if they so desire. Plus, there's always pardons, there's always commutations and sentences. Those things exist. Their expert answered incorrectly. We cross-examined him, unobjected to, I would note, left it at that. They went and kept going further. They like their whole redirect was on that point. So all we did was go through the door that they opened. And it was unobjected to. They didn't ask for a mistrial. It's now no longer timely. We've called additional witnesses since then. That's the only thing I'm addressing, because they're bringing up other things that happened yesterday that were also unobjected to. But I think it is important to note that the cases she is talking about are closing arguments, things being argued to the jury. I have no intention of mentioning anything about life in prison without possibly parole being anything but life. I expect that Mr. Brunvin, after I have no longer opportunity to respond, to say things to the effect of, his only way out is a pine box, which, again, is not an accurate statement.
You're right, the evidence in the case is that it's a body bag, I did hear that.
Right.
Mr.
So-
Liberato said pine box, I believe.
He said body bag.
Right, I'm just saying Mr. Liberato said in a pine box. So it doesn't really matter, we all get the point of what it is. But I will say that I advised the court prior to making this argument that we wanted to go look at case law, which I didn't have the opportunity to do here when this questioning was going on. Furthermore, bring on the 3851, because that's exactly what's going to happen here when he says they didn't make a contemporaneous objection. I mean, it's nothing, it would be nothing short of ineffective assistance of counsel if that's the argument. And thirdly, that doesn't give him carte blanche to be unethical.
All right,
Nothing unethical about it.
well, let's not have,
I did not misrepresent the Ramirez case. And neither did Mr. Doig in the questions. Murder of one person, it was co-defendants is what I said. 2 co-defendants went in and raped a little old lady and shot her in the head. That is the only thing I ever said. He has since been released. He was sentenced to death when they were told that it would be either life or death and that those were the only 2 options. Then he was sentenced to life when that was said that that was the only option. And guess what? He is out right now. So I think that when they bring up an expert to talk about prison and they ask the question about the only possible alternatives, that they invite the cross-examination on, well, actually, that's not true. So,
all right, well, maybe it's not 100% true, but that's what we're supposed to tell the jury. Okay, so I'm not going to grant the mistrial, but I am going to give that curative instruction. Okay, and then on the Ms. Delaparato thing, I mean, obviously that could be admissible as far as her bias. I mean, obviously she's very anti-death penalty, probably as anti as you can, but I assume you had some good faith basis. I mean, you didn't just make that up.
I was promised 100% certainty by an attorney we all know in my office that that was the case. And the attorney still stands by it, despite the answers from the stand, so.
All right, well, you know, I was thinking when she was up here, maybe the answer is not at all, but you asked about the neck and she said no, maybe it's on a different part of the body or maybe it's not there at all. But anyway, you had a good faith basis to ask that, and you were asking a lot of questions about her potential bias, and that's all admissible questioning. So, and that's about it there. So I am going to give that curative instruction. The state's not going to mention anything like that in closing. If you guys want to bring it up and say, well, you just heard what the judge said, and then as I brought out during cross, the law changed for juveniles, but it's not going to change for adults. I mean, you can do that. But that's up to you. I would ignore it if I were you, but you can do that if you want. All right. Anything else before we start on the jury instructions? See, I knew we should have them come back tomorrow. I just knew it. Okay. All right. All right, so do we want to do yours first? What I really need to know is what is, in addition thereto, or inconsistent with the standard instruction so that we can figure that out and I can rule on that. So,
Judge, I think that my proposed final instructions are 8-4 instructions. I drafted them as 8-4 instructions because the court had previously denied all unanimity requests in this case. So my proposed final instructions are 8-4 that are, we can go through the courts because then I can tell you what I put in
Okay.
mind. Do you see what I mean?
yeah. Yeah, I did notice that you basically,
Do we have a new set of instructions?
no, I still have the old ones. Do you guys still have them?
I have the old ones. Yes.
Okay.
I just want to make sure I wasn't.
Right. No, so we'll go over those. All right, everybody has them. All right, so the way I did this, and as I said before, was to do it consistently with what we do with the guilt phase, how we divide it up into sections, and quite frankly, I think it's a lot easier for the jurors to understand. We have aggravating factors first, and that's all by itself. We also have victim impact evidence all by itself too. The reason I did that is to make them understand that those two things are separate. If it's in the middle of aggravating the factors, it seems like it is an aggravating factor, so I think this is better. By the way, I proposed this to the jury instruction committee, and they unanimously passed the idea of doing this, by the way, having that separate. And then we have mitigating circumstances. All right. Do you remember I said last time, weeks ago, that I wrote something here in weighing the evidence somewhere that you may not like? So I'll just tell you what it is. And this is about the only thing besides the format that's different from the standard instructions. Normally, on weighing the evidence, all right?
Judge, are we going to go back and go page by page?
Yeah, we are. But I'm just doing an overview now. All right. So normally on weighing the evidence, right after it has numbers 1 through 10 or whatever it is that's applicable, it says whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. So I changed it to this because even though the defense doesn't agree with this, they have the burden of proof by the preponderance of the evidence for mitigating the circumstances. And there's a case that just came out last week that said the same thing. They cited the Lloyd case. And in Lloyd, the court said that the mitigating circumstances has to be established. It has to be established by the defense, and the burden is with the preponderance of the evidence. And as I said from the beginning, that's the lowest burden you could possibly have. Nothing can be established unless it gets proven. And that's what the burden of proof is for with the defense. I mean, it can't get any lower than that, right? So that's Fletcher versus State came out last week. 50 Florida Law Weekly S10A, and they cite the Lloyd case 379 Southern 3rd at 1080. All right, so this is what I did. All right, instead of saying you've got the state's burden of proof, blah, 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 since they both actually have a burden of proof, I have whether the parties have met their respective burden of proof does not depend upon the number of witnesses they have called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. So
You might want to change exhibits they have offered, maintain consistency.
okay,
But we would agree with the changes, Judge.
okay, they have offered. Yeah, you're right.
And we, of course, disagree as the.
Right. Right.
And
So
I think also some of these that I'll be objecting to today or objecting to during the preliminary.
that's fine. I mean, that's fine. You can absolutely have it preserved. As I said before, I think this is a case where all of your objections are preserved. So and I divide everything else into different subjects here. I just think it's easier for them to comprehend it just like we do at the GIFOs. First of all, any objection to the format that I invented? I'll use the word invented here.
None, Judge.
Defense?
Judge, I don't know that I have any particular objection to them being on separate pages or that sort of thing.
Okay.
Just,
Right, just what things are said on the pages you object to. Okay. All right, so page 1 is the title page. We'll change the date to the 25th. That's tomorrow. Otherwise, any objection to the title page?
None, Judge.
Okay. Then we have introduction to final instructions.
Other than those should not be the final instructions, but other than that, no. So the introduction to the final instructions, Judge, this paragraph is not individualized. It should, at a minimum, say, quote, on each count should be in there, because it sounds like a collective sort of decision. Now you can decide whether he should
All
be
right.
sentenced to life or death.
All right, so at the end, I'll put on each count. What do you want me to say for each victim? Which one do you want?
Say for each count.
For each count? All right, and then on the verdict forms, I do have the count number and then the alleged victim in parentheses, so there's no confusion there. I would have thought you might have put Richard first since he was killed first. But,
I was less involved back.
yeah,
I generally do try to do the counts in the orders of the people.
yeah, okay. All right, so any other objection besides that?
Not on that page.
All right, right. All right, then we got aggravating factors. I'm going to mention to them that hack would only be applicable for Richard and Nicholas and not Laura. All right, so take a look at that. See if you have any objection to.
I do, Judge.
Okay.
So as to aggravator number 1, again, I would cite to the ACCA case, that's ACCA of U.S. versus Johnson, and the vague language in the residual clause, and it being essentially a directed verdict on that.
All right, well, the stipulation that you signed is a directed verdict, isn't it?
Well, Judge, remember, I wasn't waiving any objections, but for purposes of what the stipulation, we agreed to that.
All right. All right, well, I don't know if he had to say the last part, that, you know, it was another capital felony or a felony involving the use of violence to another person. I mean, you could have just agreed that he was convicted of manslaughter on December 13th, or whatever it was. All right, so I'll overrule that.
And then, Judge, where you, at the end, where you say the kind of crime that is intended, this is on the aggravator. So the last line says torturous to, I know Laura's coming out of there.
Okay, we're taking Laura out. That's a good catch.
Right, but it says torturous to Nicholas Ivancic and Richard Ivancic. Again, you're grouping those two people together. It should say maybe or and or. It's not really individualized, and that would be a violation of the Eighth Amendment, would be my argument.
All right.
You want to just make it generic, was unnecessary torturous to the victim?
Well, that doesn't really make any sense either, because you've got two.
But it's a definition, so all it's doing is defining what it means.
Right, but I don't want to group these two people together. So,
Yeah, I think
Would it be take out,
maybe you said and or.
I'll just say or, right? I'll just say or. Kind of crime intended to be included as blah, 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 was conscienceless or pitiless and was necessarily torturous to Nicholas Ivancic. Well, yeah, is or okay from the state's point of view here?
That's fine.
All right.
Because it's a definition, I think you could do a very generic torturous to the victim, because the whole point is that you now have to apply that to each count, but if they want to put an or, I have no problem with that. I'm going to be very explicit in explaining how the law works here. It does not work, so I'm not going to be trying to get an aggravator for Richard because they believe it applies to Nicholas. So I don't think there will ultimately be any problems here.
All right, so would you rather have victim or?
Judge, I would put torturous to Nicholas Ivancic, excuse me, and or Richard Ivancic. Because that way, if you just put or, they might take
All right.
one. I know you wouldn't think so, but they might take one.
All right,
like
and
the
/ or. State have a problem with that?
I don't have a problem. That's
All
what
right.
the defense wants.
All right. Anything else about aggravating factors? All right, so you've been on the next page.
Yes.
All right.
The second paragraph from the bottom. I would ask for the following modifications. It says this second paragraph from the bottom. For each victim individually, if you do not unanimously find that at least one aggravating factor was proven by the state beyond a reasonable doubt, then the defendant is not eligible for the death penalty, and the defendant will be sentenced to life without the possibility of parole, and your deliberations are complete.
And we would object, I think, that the paragraph as written is more clear than what defense counsel just said.
Yeah, I think it's pretty clear when you say for each victim, it means for each victim, so. Sometimes redundancy can make things more confusing. All right, so I'll deny that one. Anything else on aggravators?
No, Your Honor.
All right, then we got victim impact evidence. Any objection to that?
The next one I had is, maybe I have it in the law, I do have it in the law.
Yeah, I had victim impact after that.
Yes, so I would request you have heard information, because if they're not to be considering it as evidence, you have heard information about the impact, and then add a paragraph after that one that says you may not consider this information when you decide whether the aggravating factors are sufficient for the death penalty, or when you weigh the aggravating factors against the mitigating circumstances, or when you make your final decision on the appropriate penalty.
We would object. One, I don't think that's the law, and two, I think that the instruction is very clear as written.
Well, it's-
Yeah, I'm going to
It is the law.
deny that. We'll do it as it's written.
Yeah, Your Honor, that gives me concern, though, if Mrs. Arabia thinks that it's not the law, that the victim impact statements might not apply to the final decision.
All right, so you're not going to mention victim impact at all, right? Okay, so it doesn't matter what he may or may not think. He's not going to say it, so. A lot of times I'm up here thinking things, but I'm not saying it, so it's perfectly fine. All right, so mitigating circumstances.
Second paragraph, Your Honor, I think that it's, when it says burden to prove, I think we're burden shifting pursuant to Lockett, when in line 4, it's indicated that we must prove those by the greater weight of the evidence. Again, that's not in the statute, conflicts with the law itself, and those should not be in there.
All right, so I'll deny that. That Fletcher case, by the way, that I mentioned before, rejects the argument that victim impact statements should be wholly inadmissible. They say we have to follow Payne versus Tennessee, and again, they say that the burden of proof is on the defense to establish mitigation by the preponderance of the evidence. They mention Lloyd because in Lloyd, the defense objected, and in Fletcher, they didn't object, so it was a fundamental error issue, but they said, hey, we're following Lloyd. All right. All right, on the mitigators, do you want any of the statutory ones?
Yes, Judge, I think that there's been evidence to support the ones that you have here. The only one that I would take out is number 2.
Okay.
I'm not sure there was any evidence of number 1.
We heard evidence, Judge.
I don't recall hearing evidence. I could be mistaken.
What, on the first one you're talking about?
Correct.
Yeah, I mean, more like on the homicide involving Jamie, you might have a pretty good argument there, right?
Right.
Well, there was evidence that between the time of that leading up to the time of the other one, we heard evidence.
Yeah, I guess
Those to number 1 and 3, actually.
yeah, I guess the extreme mental or emotional disturbance is the quote paranoia end quote of him thinking that he might get caught, right? So, I'll go ahead and give one. 3? What evidence do we have of 3?
Same as for 1.
I don't think that loop was ever closed. It affected his ability to appreciate the criminality of his conduct or perform his conduct requirements of law. I don't recall any testimony about that.
All right, well, as far as appreciate the criminality, I mean, there's none of that, because he buried the one body, and then he tried to bury other bodies, so it wasn't like he thought that what he did was not criminal. He certainly knew that. To conform his conduct to the requirements of the law. All right, well, I'll give it, and if the state thinks it's weak, I mean, these weaker ones are more fun to argue against than the stronger ones, right? So I'll give 1 and 3. Obviously, 3 becomes 2, et cetera. All right, do you want number 4, which is
Yes.
Shelby Nealy's age? Okay. One thing about age, everybody has one, right? All right, and then we've got, I think I might have taken 1 or 2 out because I didn't think it applied at all. But I forget what I took out. Do you have that from the statute?
I don't have
Just
it.
have your original.
All right. Oh, okay. Yeah, I have the standard one. It's got to be in there. All right, I didn't put in there, has no significant history of prior criminal activity because of the manslaughter. You don't want that one, do you? And then he also has the domestic violence with Caitlin, right? So,
Yeah,
I mean, if you want it, I'll give it.
we don't want it.
Okay. See, I didn't think so. All right, then let's see what else. All right, and here's another one I didn't even put in there. The decedent was a participant in the defendant's conduct or consented to the act. You don't want that, do you?
No.
Right. All right, now here's another one I didn't give. The defendant was an accomplice in the first-degree murder committed by another person, and his participation was relatively minor. He worked by himself, right? So you don't want that one. All right, so the other ones I'm giving, all right? And then 8 becomes 4 at this point. The existence of any other factors, blah, 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 including but not limited to the following. So I can, you know, there's 30 or 36 of them, whatever, but did it get longer during lunch?
We're still working on it. We've deleted some, we've added
Okay.
some.
All right, so we'll go over everything else, then I'll give you a bit of a break,
Right.
and then we'll decide that after the break, what all of your mitigators want to be, because obviously I have to get my JE to type them up, number
Sure.
one. Number 2 is it's fair to the state so they know what mitigators you're asking for, so they can prepare arguing against them if they want, right?
We'll email them so they can be cut and paste. They don't have to type them up.
What, you mean my JA or them?
Right.
Oh, you mean-
Oh, the state's gonna do it, okay.
You mean we're not gonna get them until 8:30 tomorrow morning? Is that,
No, today, this afternoon.
okay? Like when this afternoon? I'd like to.
We're gonna have a break.
Okay, we're gonna have a break,
Okay.
and then when we come back,
Right.
you know, if you typed up 30 of them and you're adding 3, you can just write them in. I just have a feeling you may not have the best handwriting, but I'm sure someone has good handwriting over there. All right.
Finish what we're doing here, and then we'll do that.
Right. Okay, so then we have weighing the evidence, okay? And the first 5 always come in, I assume that they would come in a sentencing hearing too. And I don't know, does the state want, has the witness been offered or received any money, blah, blah, blah?
Yeah, we asked for that one.
Okay.
And what, just so I know, what evidence are we talking about?
Well,
All of your
It-
experts.
2 people are making $10,000 and one person's making $4,200, right? So, I mean, if they want that, I'll give it.
Yeah, I leave it in.
Yeah, okay. All right, had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Anyone want that one?
No.
Okay.
I don't think there's any evidence of that, but I would err on the side of leaving them alone.
Well,
It's a consideration that it has not been done for all of the witnesses.
no, I haven't heard anything to get that. Okay, how about a prior inconsistent statement? We probably had one of those, right?
No.
But we haven't?
It may have been one or two. I'd leave that.
Yeah, yeah, I remember going into depositions, remember that?
Right, but I don't
Right,
think
but
there
he
was.
wasn't able to find the spot where
Right.
that happened.
Yeah. All right, well, State, can you think of an instance where there's a prior inconsistent statement?
Mr. Paul Swensen said he must have misspoke when he said something different at his deposition, because I did point him to that.
All right, we'll leave it in. All right, 9, I don't think we have anything where someone's been convicted who actually testified, right? And we don't have number 10, right? We all agree on that.
Yes.
All right, then we have the next paragraph that you don't agree with because you don't think you have the burden of proof. And then we changed some grammar. Besides that, any objection to the wording or anything at all?
No, other than what you've already stated.
Right, okay, very good. All right, law enforcement witness comes in, expert witness comes in, the testimony of a child comes out, the defendant in this case has become a witness, that comes out. It is entirely proper for a lawyer to talk to a witness, that comes in. You may rely on your own conclusion, that comes in, right? All right, does the defense want defendant not testifying? I assume you would.
Yes. But going back to the
Yeah,
defendant in this case has become a witness.
yeah.
Well, he didn't take the stand. There was 4 hours of.
Right, but he was not a witness though. So I do have defendant's statements, which are coming up.
Okay.
Okay. All right, so defendant not testifying. Any objection to that?
Defendant not testifying?
Right.
No.
Okay. All right, defendant's statements. Any objection to that one?
No objection.
Okay. Weighing process, this I just took out of the standard. Everything is standard, by the way, except for that one, with that one sentence about the burden of proof. Each side has a burden of proof. All right, so weighing process, it's just by itself, otherwise it's from the standard instruction.
I would just object, Judge, to again where it says proven mitigating circumstances on the burden of proof issue.
Okay.
And after the very last paragraph,
Oh, you're asking for a mercy instruction?
yes, and I filed a motion back on May 6th of 2024 with 3 alternatives for a mercy instruction. So I'm asking for any one of those wherein the jury can, may always consider mercy in making that determination.
All right, well, the Florida Supreme Court has said that what's here is sufficient. This is a mercy instruction. The law neither compels nor requires you to recommend that the defendant should be sentenced to death. I understand you may not think that's much of a mercy instruction, but they say it is, and then you can argue mercy, obviously. All right, then we're on to verdicts. This is another thing that I changed. I just changed the order of the paragraphs. But they had if fewer than 8 jurors, blah, 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 and then if 8 or more jurors, blah, 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 then you will be provided with verdict forms. So I put you will be provided with verdict forms first, and then if fewer than 8, and then if 8 or more. It just made more sense to me, so that's one thing I changed.
Object to the recommendation language and any recommendation language within these instructions as a Caldwell violation and diminishing
Okay.
the responsibility of the jurors.
Right. It's in the statute, and the Florida Supreme Court has said that it's a recommendation, but on the verdict forms, I'm going to call them verdict forms, we're going to call them verdicts, and I've told them from the beginning how important their decision is. All right, then we have rules for deliberation. I think these might be a little bit different. I didn't draft them, I think the jury instruction committee did, so it's consistent with the death penalty case. There's only 5 of them instead of 7 of them. Yeah, one of the things you have to take out is your duties to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Obviously, that has to come out. There's even case law on that that says that needs to come out. So what else came out? I think they took out whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. I mean, we go on and on and on about aggravating factors have to be proven beyond a reasonable doubt unanimously. So I think they just took out 4 and 5 on the normal ones. So any objection to that?
Yes, Judge. On the number 3 on your rules for deliberation, where it says feel sorry for anyone, and also on number 5 where it says or sympathy.
Yeah.
I raised those objections before.
Right.
Equating that with mercy.
And I guess I didn't, oh,
And I think the court previously ruled on that.
yeah.
The previous year.
I did. I'll go ahead and put it on the record again. All right, Wilson v. State, 50 Florida Law Weekly S89A, that I think came out May 22. For some reason, I remember that. Does the instruction that the jury's decision must be based upon the fact that you feel sorry for anyone, the jury's decision must not be based upon the fact that you feel sorry for anyone or are angry at anyone. Issue, does it violate the 8th Amendment? Answer, no. So they think it's fine. That's the Florida Supreme Court. So we'll stick with that, but all your objections are preserved. All right. Anything else on rules for deliberation?
Not that, no.
All right. Cautionary instruction. Should we say, well, it says deciding a verdict. I guess that's okay. I mean, we do that in every case where there's more than one verdict, but if you want, I can say, yeah, I think it's fine. What do you guys think?
Cautionary instruction, I'm fine. I'm fine with the cautionary.
Okay. All right, everyone's fine with it, right? Okay. Submitting case to jury, let's make sure this is consistent with a death penalty case here. Yeah, that seems fine.
State agrees.
Judge, in paragraph 2, line 4, it says you are not to communicate with any person outside the jury about this case. I don't have an objection to that line. I just think that should be the first line in the paragraph because it makes sense that way.
Well, I mean, the first line is during deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. So I'll read it as it's written. All right, anything else?
Not with the jury instructions.
All right.
And obviously, we have to put cold calculated, premeditated in.
Oh, yeah.
Well, I'll need to look at that because there's a problem with each of the individualization then.
All right, so I
So if
forgot.
we don't get it by 8:30 tonight, it should be fine.
I forgot that I forgot that one. think I have them in the verdict forms, but I didn't put in the jury instructions. All right, so that is. All right, it's number 9 on the list. So do you guys have a copy of the standard instructions? If you want, I'll read it, so.
Yeah, I'm looking at it right
The first-degree murder was committed in a cold, calculated, and premeditated manner, without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, for this aggravating factor to apply, a heightened level of premeditation, demonstrated by a substantial period of reflection, is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. So that's the standard.
I think that's fine, Judge.
All right, what says the defense about that?
Yeah, Judge, I just want to make sure, like the hack, that it says to each.
All right, well, let's see.
I'm not sure we
Well, all it says is the first-degree murder was committed in a cold, calculated, premeditated. That's fine.
Maybe as to each count, or as to each person.
You know, I think I'm going to explain that. I think the state's going to explain that. I think Mr. Bonbon's going to explain that. I mean, it's for each one. And I don't think it's really confusing if we just give this. I mean, I'm sure everyone's going to mention it's for each one. So.
Well, if they're getting written instructions that they each get to make back there.
Well, they're also getting 3 verdict forms here, right? One for each victim, right? So, I mean, it's pretty clear. You know, let's not assume that they're kindergartners. I mean, it's pretty clear, I think. So I'll just give that one as written. All right, so I think that's it. Anything else you want to argue, preserve for the record, try to convince me, anything?
Judge, on the aggravating factors, and I actually forgot to mention this on page 3 of aggravating factors. So on page 3 for aggravating factors, and also on the verdict form, for the prior violent felony, the statute does not mention the word contemporaneously. So I would ask that this aggravating factor be worded in conformity with the actual law.
All right, well, that's what the law is as far as the Florida Supreme Court is concerned. I mean, I know that the committee put that in there just to make it clear, because the law is very clear that if it's previous, and previous means previously convicted, or contemporaneous, which means at the same time. I mean, legally, they're previous convictions because the defendant pled guilty to all 3, so they're all previous. And the law is that it's previous if it's contemporaneous because he was either found guilty by the jury or he pled guilty prior to, and prior means prior to right now. So I think that is a accurate reflection of the law.
So I think it's 921.1416. On the aggravating factor section of that statute and the applicable subsection that talks about this aggravating factor does not use that word contemporaneously, and that's why I'm objecting.
Okay. That's fine.
And then also, I said this already, but also jury recommendation, the word is a
Well, you know, even when Caldwell came out, they were using the word recommendation, all right? And it was just a problem with people trying to understate what the job of the jury is. So then you had to say that the court will give your recommendation great weight. The only time we stopped calling it a recommendation was after Hearst v. Florida and Hearst v. State came out. And then we were just calling it a verdict and not a recommendation. Now it's back to a recommendation again. That's right in the statute. So even when Caldwell was promulgated, it was okay to say recommendation. You just couldn't say, oh, it's not that important, and it's up to the judge, and the judge is a great guy, so if you recommend death, he'll figure it out. I mean, you can't say that. All right, so anything else?
Yes, on the next page of the jury form where it says check only one, that,
Oh, you're talking a verdict form?
I thought I thought we were on there.
Okay. Well, we are now.
Oh, well, that's why I went to the whole contemporaneous language and the jury recommendation section.
Okay.
I thought we started on the verdict form.
Yeah, that's in the instruction too. Okay. All right, so what's your issue now?
This is on, I guess it would be the second page of the verdict form, where it says check only one. That language is not in line with the statute, that statute being 921.141(2)(b)(2). So I'd object on those grounds. I also think that each of those need to be separated out with a yes or no to be checked. And also indicated that each of those is to be made unanimously. So like one, we the jury have unanimously found the state proved one or more aggravating factors. Two, each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed, three, I messed up, Judge. So one would be, we the jury have found unanimously that the state proved one or more aggravating factors. Two, that the aggravating factors are sufficient. Three, and then four, so they're numbered like that with a yes or no blank for them to check.
Okay, and I think we did that for a while after Hearst came out, but now it's just in one big paragraph, so I understand the objection. I'll go with it as written.
So the proposed verdict form that I have, which dates back, and I think it's the still one we're still working on, from Laura, does not include cold, calculated, and premeditated.
Oh, really? All right.
I'm not sure it does for any of them, but also,
Huh.
we don't need the heinous, atrocious, or cruel.
Oh, okay, here's what happened, okay, is we took out the wrong one, so.
No, Judge, I think in the other ones it also does.
Well,
Cold calculated.
no, I have it in there. That's the last one, right? Unless I changed it after.
The one I have, has it in there?
Yeah, okay, so,
Sorry, the one that I had
You-
ends with hack for each one, so I must have an outdated version.
yeah,
That's the one I have too.
Yeah.
yeah, all right, so, all right, so I'll show you these, okay? Now for Laura, I think we took out the wrong one, okay? No. No.
And
No.
again, I'm working off the copy.
Right, that's probably obsolete,
Okay.
okay? So come up here and look at these. So I apologize for that.
And Judge, for the verdict form for Laura Ivancic, her last name is spelled incorrectly, at least on my copy, it should be C-I-C.
Okay. Thank you. Yeah, that's just a typo there. Wait, I-V-A-N-C-I-C?
Yes.
Okay, so that's, I think we did that for everybody.
Yes.
Okay. I didn't mean to do that. Anyway, you guys are good at finding typos and stuff. That's good. All right, so, but there they are. So for Laura, we took out hack, and for all of them, we put in CCP.
possibly parole, I think a vote would also be prudent, only because I don't trust the jury's math.
I agree with that. Been there, done that. With you, Your Honor.
Right.
That-
You're giving me PTSD on that.
I don't think that, I would ask that the court not do that.
Well, okay.
Well, she's overruled you a few times during this trial, so,
I know,
It's
I
not
know.
appropriate.
all right, I'm gonna leave it like it is, okay? So,
May I get that back, just keep these
Yeah.
in order? Thank you. Okay, let's go
well, speaking of that trial, are you gonna have any demonstrative?
I want to talk to you about that
All
once
right.
we're done with this.
Okay.
This page is blank.
to, we just didn't know if it went over. Yeah. Oh. Okay.
And only the same issue, which the court has already overruled.
Let's count for you.
Yeah, only the same objection from the last time.
All right. So they want to make a statement if it comes back life? For death. Oh, if it comes back for death.
Death for life, I think I want to make a statement anyway, but that would be the appropriate time, because I assume the
Right.
court will then sentence him to life. If it comes back
Right.
for death, I assume the court's going to set off.
Yeah, yeah.
They just,
I mean,
because they're here now, so they would have to.
on what I do. But, if it's, after I decide if it's life or death at the very end, I guess that's the safest thing to do, but,
I can let them know that.
if they want to appear by Zoom, that's fine. Now, remember Richard Jr.'s in West Palm Beach, right?
Yes.
Okay, so that's, that's pretty close.
Yeah, that's not too bad.
And then, where are these other people that got
Ohio and New Mexico.
Ohio, New Mexico.
Oh, well, if they want to appear by Zoom, they can, so yeah. If that happens, we'll send Spencer, and if you guys want to do a memo, you can, and then we'll, and then we'll set a sentencing. I guess if it comes back to life, I'll just, I'll let them talk, and then I'll impose life right then, right?
Yeah.
Right, no sense in wasting a lot of time. Okay.
I just want to let you know because they have a lot of background.
Yeah, well, I can understand that. I mean, they're probably getting a little frustrated in that the the defense family can say very. Basically just the contemporaneous, and also you want it.
It actually is.
Is if Mr. Brunvon is going to be showing any demonstrative evidence, that is evidence that was not presented during the trial,
Yeah.
or not admitted. Yes?
Yeah, so, the last time you and I had, I think it was the last time.
I think it might have been. It was a while ago, but it was
It's
the
a
last
while
time.
ago, yeah, absolutely. It's the Perella case. In my PowerPoint for the closing argument, my recollection is I had a side-by-side. I had an image of prison bars similar to this image right here, I've shown
Okay.
to the state, which is basically prison bars with a chain. The other image that I'm considering maybe incorporating instead of that would be this one that has sort of the reflection of the prison bars on the ground. Side by side with something either like this image, which is the lethal injection gurney at the Florida State Prison. I mean, I'm not going to say that that's what it is, but that's the death penalty image. Or this one, which is a more close-up of the gurney, and or the electric chair. Now, the last time I did not include the electric chair, but I did include one image of the room, basically, where you see the gurney, and one image of prison bars. It's a demonstrative aid to distinguish the two types of sentences that we're talking about. I don't think it's at all inappropriate. There's been discussions by witnesses about the difference between death row and life in prison. And about the fact that we still, at this day, the person who is sentenced to death, should that happen, has the option early on to decide either for it to be lethal injection or the electric chair. So I think it's a discretionary decision for the court. I haven't found any case law that says that this is inappropriate. I have some general case law that talks about the fact that it's a discretionary call for the court. I can share those with the court if you like. My position is, for some reason, the state has this problem with us talking about the sentence that or showing a picture of, what's used when someone's executed. It's not like anyone's laying on the gurney, but this is what we use.
Well, let me ask the state this. State, do you have any objection to the photograph of the prison bar's reflection? So it looks like a shadow as opposed to...
He showed it to me, and if that was the only one he was using, I don't see a problem with that. I don't see the value in it, but if that's all he's using, no. The other ones, they're not authenticated photographs, so all we have is their word, and I'm sure that these were selected to look as horrible and evoke as much emotion as possible. And that's really the only reason they're doing it, is to evoke emotion in the jury, which is inappropriate and would not be inappropriate demonstrative.
All right. I'll allow this, the shadow or the reflection of the bars, you can do that, and then the long-range shot of the gurney.
Okay?
All right, just
Those
those
the
two.
long-range shot of the gurney sitting in the room, not the close-up,
Right,
and the one that has the reflection on the floor.
right,
Okay.
right, and they're gonna be side by side?
I'll put them up side by side.
Okay,
And then the only other thing that I will alert the court that I would include in my PowerPoint would be language from the jury instructions and possibly some small segments of the interview that's in evidence.
okay,
That's it.
that's fine,
Okay?
all right.
Three things. One, I assume the court is denying my motion request for court to give defendants proposed final instructions that was filed on July 7th of this year.
Correct.
All right. And then, Judge, I'm asking the court to give a special instruction because I think something was asked of Dr. Lowe yesterday about this. And I would ask the court to give an instruction that says the law does not require a connection between the mitigation and the crimes.
I remember reading that already. I think I read that in the preliminary instructions. Let me see if it's actually in the instructions.
We're not going to be arguing, I mean, obviously, I'm sure they're going to come up with a number of mitigators. There does have to be a connection between the stated ones where it says it is capacity to appreciate the criminal conduct and the crimes. You can't have a limited capacity and it not affect your, so I think
Right.
I think you will overcomplicate it and make
Yeah.
it too.
All right, under mitigating circumstances, the second sentence, a mitigating circumstance is not limited to the facts surrounding the crimes. I think that's good enough.
Right, but that's different than saying there doesn't have to be a nexus between the mitigation and the crime.
I think it's close enough, so I understand your request, and I'm gonna go with what's written here, okay?
And then, Judge, I know you said you were gonna give a curative instruction.
Yeah, I am.
Right, but could I know exactly, I don't know if the court's gonna write it or somehow so that I can review it to make sure that if there's
Well,
anything I need to.
Well, I'll tell you what, during the break, if you want to draft something, then at the end of the break, I'll take a look at it.
So then we need a little bit of an extra break so that I.
Okay, that's fine, that's fine. So it'll be something like, obviously the verdict will be either the death sentence or life without the possibility of parole, and that means that the defendant will never get out, and that law is not going to change, okay? Something like that, so obviously you can do better if you have extra time. All right, so how long do you think these closings are going to be? Do you have any idea? State, what do you think?
I don't know how many mitigators they're coming up with yet.
Well, a lot.
So depending on the mitigators, I'd say an hour to 2 hours.
Okay. Defense, what do you think?
I don't know. I would be shocked if I did more than 1 hour.
Okay.
So,
I'll say this, Judge. If the defense wouldn't object to me using a PowerPoint that includes digital versions of the evidence, I think I can go a lot quicker.
I don't see why you
I
can't
don't
do
have
that.
any issues. I believe both sides, and I believe it's appropriate for both sides to incorporate into the PowerPoint anything that's been introduced into evidence.
I agree.
Okay.
All right, so,
I may do that
Okay.
to make it go faster.
all right, good. All right. So should we go ahead and take our break now, and in the meantime, you'll work on your mitigators and that curative instruction?
Yes.
Okay.
Maybe 30 minutes?
Okay. We'll see you in 30 minutes.
All right.
All right, you may be seated. All right, so defense, do we have a list of your proposed mitigators?
We do.
All right, has the state seen them?
No, we just finalized it. I'm gonna email it to the state right now.
Okay. All right, so why don't you email them that? Why don't you show them the curative instruction? And then we'll come back in a few minutes and then we'll talk about it.
Yeah. I'll add the curative instruction to the email that has the.
Would you like a copy of that as well?
Sure, yeah. Yeah, can you email it to my judicial assistant?
Yes.
A. Wynn?
My secretary over here.
Right. Formerly T. Wynn, right? Yeah, yeah, I know. But she knows who she is.
But I know her by both names because of Facebook.
Yeah. All right.
Annie is your.
Yeah, it's A. Wynn.
Right.
All right, so.
Is section D a different, does somebody else get that, or does she get that? You don't know.
I don't know. It's separate. I think she gets both of them, but I think she's probably more apt to look at hers as opposed to the section. I don't know. Even the state has a section D1, right?
I know in Pasco we have section emails too.
Yeah.
LTA for the section check.
Yeah, like you have individual emails for each person, and then you also have one for the section. And that just goes to the LTA? Is that the story?
Well, it's a separate one. The LTA has to actively go in and check it.
It's kind of
We sort
obsolete.
of rely on them to look.
We did that before we had individual emails, then we got individual emails, but yeah, they used that for the calendaring, so they didn't completely get rid of it.
Okay. All right, so I'll come back in 10 minutes. Is that long enough for you guys to look at it, or? All right, I'll be back in 10. All right, maybe seated. All right, I got the laundry list, but I didn't get the curative instruction.
It's in the body of the email.
Oh, okay.
And we're gonna send you an updated list, because we've had some discussions with the state.
Okay.
Actually, why don't we do this? The updated one, they're okay with, the only thing that they're challenging is 15. So before we send you the updated one, maybe you can make a decision of 15, and then we can let you,
Wait.
Well, I'm sure he was immature and naive at some point, so, are you saying that he was immature and naive at the time of the offenses?
No, Judge, there was testimony that he was immature, and since that time, he's become more mature. His mother
Right.
actually was the last one to testify about that.
Right. Well, I mean, isn't everybody immature and naive at one point? I mean, is there a time period you want to put on
I
that
mean,
one?
that's an argument that could be made. I mean,
All right.
it's one factor
Okay.
out of 30.
But yeah, he was immature and naive at the time of the crimes, or when he was 2 years old.
Well, I don't know that
preschool.
it matters.
All right.
It's the no nexus argument again. I mean, it doesn't have to.
Okay. Right. I mean, but okay.
They want to leave it in like that.
Fine. All right. How about 19? Is there any of that? Is it in a report or anything like that? Because I don't remember hearing that.
Which one?
19.
Yeah.
They wish they had that.
Ms.
message.
Deliberano,
We
I
have it still.
think, said that.
Did she? Okay.
Testified here, say statements that they were vague guards, she doesn't know their names,
Okay.
said that.
All right. Then at 21, I heard third grade and I heard sixth grade. Right?
I thought it was sixth grade.
Yeah. I think somebody said third grade at first, and then someone later said no, it was sixth grade. Remember that?
But I think
If
we've
they want
changed
third
that.
grade, Judge, I'm perfectly okay with third grade.
We changed that, remember?
We've changed it. We made
Yeah,
it.
you must not have the updated list.
No. Okay. Okay. So it's the sixth grade now?
We changed
No.
it to that he was held back.
Oh.
We can't
Okay.
write that agreement on a few things.
All right. Okay. All right. And so I don't have the update, by the way. All right. All right. Then here's another question I had. 7 and 31 are pretty much the same thing. I mean, if you want both, that's fine, but they should probably be in order, right? The 7, Shelby has had neurological testing and reports that his brain is abnormal. It's abnormal because he's in the 63 percentile on 1 on the verbal and the 1 percentile on the nonverbal, right? And then you got 31, which is talking about that very thing, right? So it just seemed to make more sense to me that if you want both, they should be in order, right?
We can put it between 30 and 31.
7 and 31.
So
No,
right-
I'm saying maybe we'll
Move
move it
7.
from 7
Oh.
down to before 31, the current 31 anyway.
Okay.
You want me to resend our proposed,
Yeah. Yeah, if you want, you can send it directly to me, okay? So I'll, because she gets here at 7 and then she leaves at 4. Those are her normal hours. But if you can send it to her before 4, she'll print it out.
yeah,
Okay.
This is the instruction or the?
Well,
both.
both, yeah. How does the state feel about that curative instruction? I know you're,
We object, because
Okay.
Max is here to assist us.
okay.
Sarah Mack for the State Attorney's Office. So part of our concern.
You've been a big part of this trial. Video expert?
Yes, Your Honor,
Okay.
thank you.
Anyway, go ahead.
So part of our concern is that if you are giving an instruction to the jury, that instruction has to be a lawful instruction, and this is not a lawful instruction. And there's quite a few reasons it's not a lawful instruction. So one of our biggest concerns is that There are multiple ways for defendants, even those who are on life without parole sentences, to be released from the Department of Corrections early. I mean, two prime examples of that are compassionate release and conditional release. And even people with life without parole sentences are still eligible for both of those programs. So you cannot tell the jury that there is no possibility for a defendant, even with a life without parole sentence, to never be released from the Department of Corrections, because that's just not true. So that is a factually incorrect statement.
All right, but don't we
You
kinda tell them
you might
that
be able
from-
to tell the jury other things, but the way that this is currently worded
Okay.
is not legally correct.
All right, so what's your solution as to how to word it?
Well, to be fair, the state believes that the testimony, that there's nothing about the testimony that was elicited that is actually incorrect.
Well, I mean, there are plenty of things that are correct that are not admissible, right?
Yeah, but the defense opened the door. Like, we didn't bring up that topic. They brought an expert from the prison they specifically went through the line of questioning. So the only two ways he can get out of prison is the execution or otherwise in a body bag. We didn't do that. They did that. We cross-examined their expert, who clearly didn't know what he was talking about. That is all fair game. They opened the door. We're not going to bring it up again. They're going to get the jury instructions they get, which say the things that they say. There's no reason for the court to intervene any further at this point, especially when there was no objection. There was not. They continued to go down the road too. Once we did the questioning, then they continued to go down the road. So,
Well, it's because you brought out that Ramirez case, and that was a juvenile, and they brought out the fact that the defendant's not a juvenile, so that's not going to happen to him. Right?
Right, so that's a little
I
bit
believe Ramirez was on
disingenuous
recross,
in that-
Judge. Ramirez was recross.
Yes?
I believe that's a little bit actually disingenuous in and of itself, because then, it was egregious to do that in the first place. And then to further go, and then we then find out, oh, this is a juvenile resentencing case, which of course is nothing like what we're talking about here.
Right, except it does bring up the point that laws change, right? Because at the time, it was life in prison without the possibility of parole, and then it turns out that he did get paroled, or
But does
released,
we have-
right? So, I mean, that was the point of that, so,
I've read the case law. There's nothing that's overruling these cases. These cases are completely on point. And in fact, the card case, besides the instructions that were given, they were given certain instructions, and then it says, in addition, the jurors were instructed that life without the possibility of parole meant, quote, life, natural life of a person, no parole, end quote.
Right, those are old cases. It was about closing argument. There was nothing in those facts where the defense invited the error. When the defense made it an issue, it's completely inapplicable here. Again, they brought up the issue. We didn't bring up the issue. They want to operate under this myth that there's no scenario where any of these people can ever get out. And it is a myth, as we all know. So we're not going to highlight it. We're not going to bring it up. The jury instructions are what they are. But it is improper for the defense to be able to lie to this jury and get the court to lie to this jury. Because we all know that's not true.
It's not a myth. I mean, I would put my home, every asset I have, on the idea that he will never, ever be released from prison under any circumstances. Even if he's good friends with the President of the United States, he will never be released from prison until he dies. So we could pretend that there's some hypothetical scenario where that might happen, but it's just not true.
all right. So I'm going to do what I said I was going to do from the beginning, okay? Which is, they have two choices here, and one of them is life in prison without the possibility of parole, and that means that he's not going to get out. That's all I'm going to say, okay? And that's it. I mean, we say it over and over and over again in the preliminary instructions and the final instructions, in the verdict forms, and I'm just gonna say it, and that's it. All right, because that's what the law is. I mean, that's what the law is now. Now, but the defense keeps asking me for instructions because they're hoping the law is gonna change, and my position is that we're gonna go with what the law is now and not what's gonna be in 20 or 30 years when perhaps we have elections that have consequences and we have new people on the Florida Supreme Court and the US Supreme Court and all that. I'm going with what the law is now, so I'm gonna go with the law is now, no possibility of parole. Okay, so that's that. All right, so send me what you have. I guess what's more important is the mitigators, because I'm just gonna say what I'm gonna say on the no parole.
Yes,
Okay, but if you want to send me that too.
I will.
That's fine. All right, so do you guys want to talk some more, because you made some progress? All right, if you do, fine. If you don't, fine. So I'll,
What issue are we still dealing with?
No, I'm
That's it.
sending the revised one that
okay,
has all the updates, and I'm sending what we requested, and then you're gonna do what you're gonna do.
there you go. Okay.
Right?
Is there anything new in the mitigation? Because then we're,
No, there's nothing new.
It's-
It's
it's-
what
then
we
we're fine. I
discussed.
think that,
Yeah, I haven't gotten the update, so he's just sending me the update. And then are you sending it to Annie?
I'm gonna send it to everybody.
Okay, that includes me.
I can send it to you.
Okay.
I was gonna say, send it to Andy, I can send it to Your Honor.
Yeah, she's going home at 4. I don't know if she's still there listening.
Okay.
Or,
Okay.
it's 4:01, so maybe she's gone, so
Okay.
you can send it to me. You don't mind, right?
Let me see. Why don't you give it to me just in case?
Same as everybody?
Say
It's
what?
just J. Balone.
And then I'm just pasting the same. And I'll bold it so it's easy to see. And off it goes.
Okay.
It may take 10
Yeah, I know.
minutes because there's something.
Yeah, I know. It does take a while. It has to go to the cloud in California,
Right.
and it gets taxed a lot, then it comes back. Just kidding. All right, so what I'll do is at 8:30, if you want to come in, it'll be a little bit before 8:30 too. I'll have 2 copies for the state, 2 copies for the defense right there, and then you guys can make sure it's consistent with what we said as far as the jury instructions.
Okay.
I'll have a copy up here. I don't want to make too many copies of the verdict forms, because I don't want them to get mixed up and stuff, but I'll have the verdict forms up here, okay? And then if you want to take a look at those before 8:30, you can do that too. So I normally get here about 8, a little bit before 8, 7:50, something like that. So I'll have them here as soon as I can, okay? All right, so I think that's it for today, right?
Yes.
Okay. So good thing we're not starting closings now, right? All right. All right, so we'll see you tomorrow at 10. Hopefully I'll be done at 10. We'll see.